Similar item 4, my lord. In this case, my lord, the brief has been, my lord, transferred to me yesterday. Some time is required.
Item
4, man.
4.
Yes. So, my lord, it's minimum 2 weeks time, my lord.
Okay, we are adjourning it, but normally when you receive a brief, we expect that you will also receive instructions. Instructions are 2 types. Without both instructions, you don't accept a wakalatnama. We are adjourning it, but okay. Both are represented on the prayer made by the counsel for the petitioner. List after 2 weeks. On a date to be fixed by the registry. Okay.
Obliged.
May I please, Your Lordship? Lordship, I beg to mention item number 9, Your Lordship. Lordship, it may be listed after 3 weeks, Your Lordship.
9, you'll have to wait.
Lordship.
Because you see, I am requesting the bar every time that at least on Tuesdays and Thursdays, when you make a mention, please inform the court in advance. We are listing very limited cases on those days with the intention to hear these matters.
Yes, sir.
So on Tuesdays and Thursdays, prayer for adjournment is refused. The other counsel had a different reason. No, please wait for your turn.
Much obliged.
May it please, the Lordship. Lordship, this matter is fixed today, my lord. Today it was fixed, but unfortunately not listed. May I please tomorrow, my lord? Because
Give it to the courtmaster.
I am declared.
Please, Your Lordship, I beg to mention item number 8 and 11. Kindly matter may be fixed upon next week. Lordship.
No, not without advance information. No. It is refused. Please tell us in advance on Tuesdays and Thursdays. Yes.
May I please, Lordship? Lordship, this is a read appeal, Lordship. On 29th case was part heard. It is supposed to list it on today's, Lordship. But I wait for the main cause list and supplementary also. It was not listed,
Okay.
Lordship.
Give it. Give the mention memo.
Lordship, is it possible tomorrow or day after tomorrow? Lordship, as I requested from last 3 months, Lordship, that I am
No, we
jobless.
understand, but tomorrow is a motion day. We may not have time for hearing. Give it to the courtmaster. We'll get it on Tuesdays or Thursday, any Tuesday or Thursday. 6th, it will not come because we have a fixed matter. We'll get it on 8th. 8th of May.
8th of May.
8th of May. I mean, take it for 8th of May. Yes.
Daily list item 1 for admission.
Duty order annexer 1 at phase.
Except for voters list, what is your any other good document to connect you to your projected parents or grandparents?
My lord, governance certificate and evidence of the
Which page?
at page number annexer 14, my lord.
Page.
Third page number.
No.
Page 59, Your Honor.
Yes.
My lord, Kabur has crossed by the tribunal as DW1 and he has elaborately established the linkage with his father, petitioner's father. May I read it, my lord?
Not required in this cross-examination. You have stated somewhere, this DW2, he has stated somewhere that they maintain the population register, but that was not proved. So the evidence given in form of this the certificate is a secondary evidence. The primary evidence being available was not produced. Somewhere you read, you will find it.
Yes, ma'am.
You have read it. So primary evidence was not produced. And you see, once the primary evidence is not there, secondary evidence, you'll have to show that why it should be admitted under section 65, 63 not being complied with. Because if that goes, you have no connection. You don't have a voter list with your parents.
My lord, there is voter list, with my mother, voter list 1993 is there, my lord.
Where is that?
Annexure 11 at page 56, my lord.
Just a moment. Where is your written statement? Have you introduced your mother in your written statement?
Written statement, annexure 5 at page 43, my lord.
Have you introduced your mother in the written statement?
Yes, my lord.
Where is that? Because I may have missed it, but it is not there.
Not there, Lordship. Page 43, Lordship, paragraph 5 says mentioned only his father's name and his wife's name.
That's why since
That's
I don't read
sick,
so,
Lordship.
since I don't read that thoroughly, just a vague recollection, and that's why we are asking that question. Have you stated the date of death of your father or mother in your written statement? No.
No, my lord.
Any death certificate of father or mother introduced?
No, my lord. At that time, it was not provided. Right.
No, you see, it is very difficult to accept that. The reason is, even under your in the Mohammedan community, you have a burial service
Yes.
that people are buried.
16.
Burial certificate will have to be there. It's not possible that somebody will just go there and dig a grave and then lay somebody there for rest.
At that time, they were not aware about that matter. So, my lord, there is no death certificate or burial certificate is there.
No, but you see, my experience in attending funeral service of people from Mohammedan community is that in the before the burial, they go to the office and then it is registered. They have a register of people who are being laid to rest.
My
I've been witness to many burials in.
My lord, it is happening in urban area, but not in rural area. But today, nowadays, it has been started, my lord.
No, I don't know. My experience is very limited.
And the peoples are sorry, yes, people.
No, but no, but you see, if there is no connect, we are now examining a question of citizenship. You'll have to show some link of the proceedee with his parents who were in the state of Assam before 25/3/1971. How do you connect that?
My lord, in inquiry report, the inquiry officer has stated that he has born in 1965, 1/1/1965, and
So, Lordship, if he is born in 65, after 20 years, by 85, he ought to have voted. His name ought to have been there in the voters list with his parents, Lordship.
with his
No,
mother.
because you see, parents,
No, father, because if he has to show his linkage with his father
we understand.
and father.
No, the date of death is not there. So we don't know when his father's
Passed
father had
away.
expired. That
Yes,
is why you
Lordship.
see that question was, is the date of death dated? Because if it is not there,
That information he has to give, Lordship. And the WS is absolutely vague. He's not stating when he himself first voted he has just put that the voters list of his father's name appears in 66 and 70 and his wife. No information about him or his siblings, nothing, Lordship. It was as vague as it could be.
In written statement, there is not spot used, but I have,
Oh, you know the law, no?
yes.
What has to come in the written statement, you know that?
My lord, in his evidence, the
Mhm.
petitioner has stated in paragraph 5, annexure 6, my lord, page number 46. Though it was not mentioned in petition statement.
46.
Yes, my lord.
Yes. Which
Mm.
paragraph?
Paragraph 5, my lord. Annexure 6, page number 46.
'93.
Now,
His name, okay.
please see, 1966, somebody's name is there, Gulab Sheikh of village Uziror Char,
Yes, ma'am.
correct?
Yes.
Now, mother is name appears in the voters list of 1985.
Yes, ma'am.
Now, the address is Mau Khua Char.
Yes, my lord. In my petition, I have mentioned about that due to erosion, they have shifted from Uzirasor to Maukasor. Near
Where is that statement?
in my my petition, my lord.
In your writ petition, no, that is a improvement from your evidence. Before the tribunal, you don't say that.
No, my lord. In tribunal, they have not mentioned it.
Then you have to show us some authority that writ court exercising certiorari jurisdiction would have to can be permitted to look into new matters, which is not pleaded before the tribunal below.
In tribunal, my lord, his elder brother has submitted evidence, but which was not cross-examined, where he has mentioned that they have shifted from Uzirasor to.
But your brother is not there in your written statement or in your evidence.
Yes, my lord.
Where is your brother's evidence? Which page?
Annexure. My lord, annexure 14, 61, page number 61 to 63, my lord. In his evidence, paragraph number 2, he has mentioned, my lord.
19%. Evidence from this is 16.
Where is the 1985 voter list?
Annexure 10, my lord,
Page
54.
54.
Particular as page 53.
In the written statement. बेटा को नाम है नहीं definitely. Yes. Right, right. 19, 20, 22. या ते क्या नाम है या नाम है हकीम नाम 85 voters list, Hakimuddin's name is not there.
No.
Why?
At the time,
Because he's not part of the family.
he is part of the family, but he-
Okay. To be granted.
at the time, age should be 21
Hmm?
to become a professional.
Hmm?
21 marks should at that time.
Yeah, so 85, he's 65 born,
So 20,
65 born.
65 and 85, 21 years, 20 years.
But your brother has stated everything in his evidence. Why your W is? He doesn't look so good, he was very smart.
No, I have.
You are leading us to very uncomfortable questions.
Yes.
Number one, your brother in the voters list of 1985 is 32 years. So he is presumably born in 1953. His age of voting would commence from 1974. So you'll have to show that after 1971, your brother also had existence in the state of Assam. Before 25/3/1971. You don't have a voter list when you become an adult. 1974 to 85 is 11 years. You don't have a voter list.
My brothers, my lord.
Your brother, definitely.
Altaf Hussain, Altaf.
Hmm.
Yes. Mrs. Verma.
Lordship has seen the discrepancies, Lordship. Oh, the brother has stated.
No, I have just
everything
questioned him. I did not say it. I am just questioning him.
The brother has stated everything what he ought to have stated in his WS Lordship. His WS is so vague, it carries nothing. He filed it in 16 and the brother filed his evidence in 2019. It's a complete improvised one having all the facts and
And once again, what has happened
Lordship.
is that he has, there are 8 siblings. Out of 8 siblings, in the voter list of 1985, we get only 4,
Yes, Lordship.
but 4 are again not there.
And
They are separated, my lord.
So this will always happen when you bring, when you write in accordance with the voters list. It will be separated, it will be here and there, but very strange. This, if from this voter list of page 55, your brother seems to be the eldest of all. Correct? Because he was 17, age difference between your mother and the elder brother is 17 years. So definitely before that, you would have no siblings. Very strange that younger siblings shift and the eldest one live with the mother.
But in written statement in tribunal, perhaps it has been the mistakes of the engaged.
No, we can't say that because it was drafted by a learned counsel, filed by a learned counsel, argued by a learned counsel. So 3 learned people are there. We can't find fault with that. At least not without hearing him. Yes,
Lordship,
Yes,
since
sir.
the records, Lordship will fix it up for hearing, but no interim at this stage, Lordship.
no, we are hearing it.
Yes, Lordship, then we'll proceed with the hearing.
No, we are hearing it.
Yes,
In fact,
Lordship. Good idea. Discrepancies in voters list. ROWS is vague. We'll cite our citations, Lordship. Lordship has seen the discrepancies as well as his name appears for the first time only in 93. And no explanation as to why his name is not there with his parents or siblings. The petitioner's lordship. And he has not introduced his mother anywhere in the WS. Subsequently, he's referring to his linkage with his mother, but nowhere his mother's name appears in the WS lordship. '93, where he's referring the voters list lordship, it is just his mother and him. The other siblings' names are not there. The other siblings' names ought to have been there with the mother. It's a single voter list at page 56, Lordship. That is the only voters list he has. And the Gambura certificate also, it has been issued during the proceeding when it started in 2016, Lordship. And it doesn't, Gambura certificate is basically for the married women. Gaon Panchayat certificate. Gambura, to deposition to Professor. What is the deposition of the Gambura?
Is 89.
89.
59.
59.
And 30.
Gambura has not produced any record book, Lordship, of the certificate which he has issued.
But he again has come from his childhood. The whole is able for something.
Lordship, in the cross, the Gambura has said, I simply certified that Hakimuddin is the son of Gulapuddin, but I have not mentioned the period of Gulapuddin and Hakimuddin's inhabitancy in village. I cannot remember correctly the name. I had not met his Gulapuddin's father. His statements also maybe they have shifted to the village in between the period of 1997. And without records, this certificate cannot be proved, Lordship. Now, certificate or Etutiva. Me Etutiva like
1073 of 2016. Where are people?
Mhm. Mhm. Evidence of Barbara will be not be affected. Excellent. Oral submission now. Discrepancy in voters list. Yes, Lordship.
Case number 54, Annex 10, my lord.
Mark
54.
for video. Flag mark for video.
Particular at case 55.
We will be dismissing it. It's not, we're not finding anything.
My lord, kindly fix another date while.
No. Once having spent time, half an hour is too long a time to spend for an adjournment. We'll pass orders in chambers, it will be released
Lordship,
today.
we'd like to rely on two judgments, Lordship. One is the Gaubura's certificate, Lordship. Gaubura's evidence is not admissible because it is not based on any records. And for that, I would like to rely on WPC, Lordship. WPC 1073 of 2016. Mohammed Abdul Kudus, ABDUL KUDDUS, Abdul Kudus versus Union of India, paragraph, Lordship 15.
Yes.
Lordship, Exhibit Kha 1 is a certificate issued by the Gaumbura on 2/8/2010. He certified that A. Kudus was son of late A. Kadir and that he was a resident of Botalimari village. Father was voter of Lahori Ghat constituency. A. Kudus was born in Botalimari village but shifted his residence to village Sararpatar village. Though the Gaubura deposed as DW2, he did not bring the official register or record to prove the contents of Exhibit K. Therefore, the contents of Exhibit K1 cannot be said to have been proved. It is tried that documentary evidence has to be proved on the basis of the contemporaneous record and not on the basis of personal knowledge through oral testimony. From the document as well as from the deposition of the Gaubura, what transpires is that the certificate was issued without reference to any official record. However, notwithstanding the same, even if we take the certificate at its face value, what it says is that A. Kudus was a resident of Batalimari village, but later on shifted to so-and-so village. So since the certificate is issued and not proved with the records, Lordship, it is not an admissible piece of evidence. Oral evidence, Lordship, one more.
Joy does, nothing else.
Joy does, yes, and I. Lordship, one more we would like to refer. Get it. 27 to. It here who brought us it?
On testimony.
Oh. On oral testimony, Lordship, we would like to give a, thank you. Paragraph 17, Lordship, WPC 562 of 2016.
Reported in.
Lordship, it's reported in 2018 3 GLT 118.
Name of the parties?
It is Bijoy Das, BIJOY, Bijoy Das. Decided on 18/4/2018. Paragraph 17, we are relying on, Lordship. It is right that mere filing of written statement and oral testimony in a proceeding under the Foreigners Act 1946 would not be enough. The fact in issue would have to be proved by the proceedee by adducing documentary evidence which are admissible and relevant. The two documents filed by the petitioner was not proved in whatsoever manner, and therefore the assertion. This is what we would like to rely on. Basiranat case select
Documents should be appreciated as a whole. Distributed.
and the page 2 here.
There are 30.
30.
30.
Right.
There are 30.
Lordship, one last citation we would like to rely on, Lordship. This is Basiron BB versus Union of India, BASIRON. Reported in 2018 1 GLT 372.
On what point?
Lordship, the document has to be looked into as a whole, Lordship, has to be appreciated as a whole. And paragraph 30, Lordship, please you go. Reliance placed in the case of Abdul Matali Subra can be of no assistance to the petitioner inasmuch as it has already been clarified by this court in various previous decisions that the said decision did not lay down any law and was a decision confined to the facts and circumstances of that case. Regarding discrepancies in the voters list which the petitioner contended were not her creation being entered into by the officials of Election Commission and therefore should not be used adversely.
That is a
against the petitioner.
situation not present here. In this case, it's not present.
Lordship, he has only one voters list with the mother, but no other names are not.
That's okay,
And in
but the
85
principle you are submitting, that is not available here.
Not cite this one, Lordship.
Heard Mr.
My lord, one opportunity may given. My lord,
Yes.
to fix another date.
No. If you want to take an adjournment, take it in the first blush. But after we spend some time,
Kindly
then-
allow one of.
no, we are sorry.
We may hurt my.
Please try to understand, we have a board. If you had taken an adjournment half an hour back, we would have taken up some other matter.
Sorry for that.
It's no, it's not that, it's not just permissible. We spend time and then we wash it off. We give you time till tomorrow, you turn the clock back. Take us back to 10:30. We give you 24 hours time. Some movies we saw in when I was adolescent, they are time machine. We bring back the time. If you can do it, you get it.
2 days time, man.
No. Yes, sorry. Your name?
SU
Yes, heard Mr. S.U. Ahmed, I'm counsel for the petitioner. All the respondents are there. You're for CGC. Okay. Mr. B. Sharma, CGC, and Mr. Islam on behalf of okay. Next paragraph. By filing this writ petition under Article 226 of the Constitution of India, the petitioner has assailed the opinion dated 17/8/2022, passed by the learned member, Foreigners Tribunal, 6th Barpeta. In page 17, in so-and-so, corresponding to so-and-so. They were declaring the petitioner to have to be a foreigner or illegal migrant who has entered Assam on or after 25/3/1971. Next paragraph. Referring to the statements made in this writ petition, the learned counsel for the petitioner has submitted that the inquiry by the inquiry officer was conducted in a illegal manner, behind the petitioner's back, and without giving an ample opportunity to demonstrate documents relating to his citizenship. Full stop. It is also projected that although the inquiry officer had recorded the name of the petitioner's father as Golap, Golap, but subsequently it was striked out. And therefore there was a tampering of the report of the inquiry officer. Stop. Moreover, it is submitted that in the report of the inquiry officer, the date of birth of the petitioner is recorded as 1/1/1966.
My lord, 65.
65. Okay, 1965. And therefore, the reference which was made against the petitioner was not sustainable. Full stop. In this regard, the counsel for the petitioner has referred to the case of Babulal, Babul, Babulal Hussain versus Electoral Registration Officer and others, within bracket 1995, bracket was 3 SCC 100, and Muslim Mandal versus Union of India and others, 2013, within bracket 1, bracket was GLT 809, which is referred to in paragraph 3 of the writ petition. Next paragraph. It is further submitted that the petitioner's projected father is Gulab Sheikh, Sheikh, whose name appeared in the electoral roll of 1966 and 1970 of village Uziror, UZIRAR, Char, next word, under 52 number Bagbor LSE, BAGHBAR. His wife is Tusta, Tusta Bhanu, whose name appears in the electoral roll of 1994 of village Mokhwa, Maukhowa, Char, under 45 number Bagbor LAC. And his own name appeared in the electoral roll of 1997 of the same village. Full stop, however, he was marked as a doubtful voter. Next, but it is submitted that that in course of trial of the proceedings, the petitioner has exhibited the following documents. Page 18. So and so, exhibit A within bracket, exhibit B. Next paragraph, referring to the electoral roll of 1985, the learned counsel for the petitioner has submitted that in the said electoral roll, the name of the petitioner appears along with his mother, elder brothers and sisters, -in-law of which is at village Mokhwa, Moukhowa, under 45 Bagbor LAC. And that his mother had cast her vote as per electoral roll of 1993 of village Mokhwa under 45 Bagbor LAC. Moreover, the petitioner has relied on the Gambura certificate of Mokhwa Char, Moukhowa Char and Uziror UZIRORCHAR, namely, Abdul, ABDUR, ROF, ROUF. But also tendered his evidence, but his evidence could not be demolished during cross-examination. The learned counsel for the petitioner has also referred to the evidence of affidavit filed by DW3, his projected elder brother, namely, Altaf, ALTAF, Hussein. And it is submitted that the said evidence was discarded by the learned tribunal. In light of opinion dated 21/1/2019, passed by the learned member from Foreigners Tribunal 1 Goalpara in FT case number 6832/G/2016 within bracket annexure 15. Court is inclined to call for the records of the said proceedings. Next paragraph, the registry shall send a requisition to the said learned tribunal through the following email address for sending us either the original or a scanned copy of the records. Copy of the said records. Next paragraph. Based on 20. Make it 3305/2025. We are calling for this record because we have, in course of dictation, when we checked up the records, his brother was declared to be an Indian with the same documents.
Let the records come, Lordship.
Let the records come. He has not introduced his brother. 2019 opinion, his brother doesn't come and give evidence. And you have seen Mr. Ahmed, he has never referred to that document. Had we not looked into the documents, and when we ask you what is the best document, you don't know how to handle your record. You don't know what document to place. In the process, you have wasted 1 hour of a time.
Thirty-five, Lordship.
T0 for the record. When we remember our days in practice, we had terrible fear in appearing before the courts. For many years, we did not have courage to stand up, even for a mention.
Lordship, even in the WS, he is not mentioned anywhere about his siblings.
know it,
Lordship.
but now
Very
this-
vague WS.
Now this document has come up. The same documents has been declared. Brother has been
He
declared.
has not mentioned that his brother also had a proceeding. All this ought to come together in the written statement,
See,
Lordship.
but for the time being,
No, it's okay, Lordship. We'll again pick it up that day. I will also jot down the points, Lordship. Written statement.
Item 2.
Obliged.
35 for the. তো আমার তুমি করবে তুমি করো
yes, Mr. Sheikh.
My lord, your lordship will turn to tribunal's order at page 75 onwards.
You see the records?
Yes, sir.
Yes.
Now your lordship, actually relevant portion, that's page 76. 76, 77. Para 3. May I read, my lord?
Yes. Just see the relevant part.
My lord, that 76 para 3. I have
Yes.
carefully paged the records in hand and scrutinized the documents submitted by the OP. As per police records, the OP number 1 was Abdul Kalam, son of late Mujibur Rahman, but as per voter list 1970 submitted by OP 1, Abul Kalam, son of Mujibul Haq, was the voter. Again, as per voter list of 1965, on Mojimul Haq, son of Saidur, was voter. Similarly, there are discrepancies in the name and age of Abdul Aziz, alias Aziz, in the voter list of 1965 and 1970. With these discrepancies in the names and age of OP number 1 and father of OP number 2, it cannot be said that documents submitted by the contesting OP relate to their Indian citizenship. Not a single voter list was submitted in the name of OP number 2, Mohammad Manikjan Bibi. It appears that the contesting OP collected documents from somewhere else to establish their nationality. It was held by the Honorable Guwahati High Court in WPC number so-and-so 2009 that filing some documents and picking up any name from such documents so as to establish relationship with the said person as father or mother or even grandfather or grandmother does not establish Indian citizenship of a foreigner. In view of the above discussion, I am of the opinion that the office in the case failed to prove under Section 9 of the Foreigners Act 46 that they are not foreigners of any class or description. As such, they are foreigners under Section 2A of the Foreigners Act 46. Since the OP number 1 and OP number are illegal migrants, it will be OP number 2 are illegal migrants after 25,371 and foreigners. The children born to them are foreigners. The names of office, if enrolled in any assembly or parliamentary voter list, are shall be deleted forthwith as per relevant law.
Which page is your evidence
My lord.
and your written statement?
My lord. Your lordship, the voter list is rejected only on
We
the
understand.
ground of.
We are just asking you, where is your written statement and where is your evidence?
My lord, written statement I could not annex with this petition, my lord.
Yeah.
But it is, record has come, my lord. In record it is there.
You've gone through the records, Mr. Sharma, you've gone
Yes,
through the
yes,
records. Is the evidence of the petitioner available?
Lordship, yes. Only evidence of the petitioner, Lord. think in first part, lordship it is available.
In the first
Yeah.
part.
Third part.
No, in the first part, we find the evidence of the PWs.
No, one OPW was also there, lordship.
Oh, yes, OPW.
Yes.
Abul Kalam. Okay. Yes, Mr. Sheikh.
My lord,
Yes.
Lord, my humble submission before your lordship, the learned tribunal passed the order in a shortcut manner. Just he said that there is variance in name, so it is not accepted. But your lordship would be pleased to see 71 voter list. At
No,
page 63.
Mr. Sheikh, by now you know what would be the question of the court.
My lord.
By now you must know what is the question of the court. What would be the next question of the court to you? You see, this PW1 was examined.
My lord.
This DW1 was examined.
DW1, yes.
Yes, page 73.
Yes, my lord. Page 73.
Yes. No document was exhibited. No document was exhibited.
That is there.
Because once it is not there,
My lord.
now
No,
you
not
come
the-
to the order of the learned
It
single
was
judge.
submitted. It was submitted with the report, my lord. But that is not exhibited. That,
But
my lord,
that's-
here, my lord, my answer will be that your lordships may accept it or may not accept it. But thing is this, my lord, I'm ordinary person, my lord, illiterate person, given document to the learned council. My lord, learned council is in possession of the document. It is the procedure that document is to be exhibited. That is not done by the learned council. My lord, I am a layman regarding this. So, my lord, now I am to bear this bear this
Circumstances against you.
circumstances, my lord, and learned.
Now,
Why we engaged counsel, my lord? Learned counsel is engaged for conducting my case because I cannot. But it is on record that I have exhibited following documents. So 1971 voter list, my lord. If it is exhibited, then directly.
it's not
I am the
exhibited.
voter.
The
I am the
travel,
voter.
the tribunal is not recorded that you have exhibited those documents.
Hello.
It is just considered it.
Hello.
It is scrutinized the documents.
Hello.
It's
So, my lord, my humble submission before your lordship, there is some discrepancies in the name, which is common. And I humbly submit before your lordship, Honorable Supreme Court also said that in not, at least in Assam, variance of name of voter.
no variance
And
of
variance
names
of
would we
age
understand,
of-
but when you don't exhibit any of the document,
My lord. No, my lord, that my answer will be this. My answer will be this, that I have handed over the documents to the learned counsel. And if the learned counsel, either of ignorance or of negligence, do not exhibit those documents, my lord. And for that, my citizenship will go, my lord. That your lordship will consider. But at this stage, my lord, I cannot improve my case. Because in the trial, my lord, documents were not exhibited. It is the duty of the learned counsel, my lord. I do not know regarding this procedure. That is why I engaged counsel. So, my lord, in that case, my lord, at best I can pray before your lordship that a chance may be given to me because case is not properly conducted, my lord. Let me produce those documents, let the tribunal consider it again. Let me exhibit. It may be so that your lordship, that if I exhibit the documents, my lord, and thereafter, if the court finds that no, I found that these documents is not proper. But regarding exhibit point, my lord, your lordship will consider. A chance may be given to me. What documents I have, let me produce before the tribunal, my lord. That much I can pray before your lordship. Because I cannot improve the case before your lordship.
Lordship. Lordship, Honorable High Court, Lordship rightly decided the case, Lordship.
I think I have repeated this on many occasions. You see, you and there are a few other learned lawyers who are who may be able to influence the lawyers in your foreigners tribunal to have some basic training from you all. At least you can give that amount of training to these people, the lawyers in in few of the bars, to upgrade their skills. They're not upgrading. The problem is that even if you want to take a view which you have argued, but then we are in appeal. Even before the single judge, it was never raised. And that is the problem when somebody starts arguing without looking at the trial court record, because that was never examined even before the single judge. Have you seen the records? No. In this record, you will find that all the documents were marked as exhibits. But later on, when these were not exhibited, the learned tribunal has struck out this marking of exhibits and did not sign it because there was no exhibits. Those were written and then struck off. So once the evidence does not disclose to have been laid, it becomes a very tough job for the appellate court to find fault with the order of the single judge.
No, my lord, in that case.
Because
my
now
lord,
we are only limited, we have only limited jurisdiction to examine whether the
Your lordship pointed out now, my lord. The documents exhibit mark is there, but it is not exhibited, that is why it is stricken. Now your lordship would please to consider. My lord, times and again, your lordship said that in writ petition that power of the writ court is very limited, but your lordship will consider for the ends of justice, my lord, as the documents were before the tribunal, only because of technicalities, my lord, those cannot be exhibited. May I pray before your lordship, a chance may be given, let us see. And thereafter,
we will
my lord,
examine it.
Thereafter, my lord, if the learned tribunal again find that no, after exhibiting also, there is no case. Because, my lord, it is a question of citizenship.
We have taken note of your submissions.
My lord,
We'll see how it turns out.
my lord. But,
Lordship,
because, my lord, actually, your lordships have looked into whether in the facts and circumstances of the case, that if the matter is not remanded back, then justice will be done to the poor client. Because he is a layman, my lord. He handed over documents, and it is also that exhibition was there, but due to technicality, it is not accepted. That is totally in the court procedure, my lord. That is beyond the control of the petitioner before your lordship.
each and every document, Lordship, which is available before the tribunal. Each and every document, Lordship, which is available before the tribunal, Lordship, tribunal has discussed the same, Lordship. And Lordship, what petitioner is relying now, Lordship, it is a Gabura certificate of post opinion document, Lordship, to page 49, Lordship, 27/6/2015 document, Lordship. Opinion was passed in the year of 2009, and High Court judgment was passed, Lordship, in the year 2015, Lordship. So this document is
Page number
page number 49, one document, Lordship, Gabura certificate
49.
49 of the writ appeal, Lordship.
No,
Is 49.
no, 49 is 14 is a part of writ petition, second page cause title of the writ petition.
No, Lordship. In read appeal, Lordship.
Yes,
157 of 2017. I think
Yes.
there was a review also earlier it was filed.
no, we are having the document of writ appeal. Pages are not matching, that means. What is the document?
One Gaubra certificate dated
Gaubra.
27/6 and
Gaubra certificate.
Annexure C.
Yes, Gaubra certificate is there.
Yes, 27/6/2015.
Yes,
Yes, Lordship. Then Lordship.
that is page 36 in our brief.
Yes, Lordship. Then Lordship.
Oh. Both of us have different pages, but we got the document.
Yes,
Annexure
Lordship.
C,
Yes.
Gaubra Praman Patro.
Then another Gaubra certificate was they have collected Lordship in the year of 10 to 2010. Page in my read appeal, Lordship, it is page 67. Annexure 4.
Annexure 4.
Yes.
Annexure 4, there is no Annexure 4. Page number?
In my petition, Lordship, it is page number 66.
Ah, yes, we got it.
10 to
In our brief, it is
2010.
page 67.
10 to 2010, Lordship, post opinion document, Lordship. Then, Lordship, there is.
Just a moment, just a moment. Yes.
Then another document, Gao Panchayat certificate, Lordship. It is President Gao Kolmobari Gao Panchayat has issued that certificate, Lordship, dated 6 to 2010, Lordship.
Yes.
Yes, page 71, Lordship. All are post 71 document, Lordship, and Honorable High Court cannot go beyond the record which is placed before the learned tribunal, Lordship. As we are here under certiorari jurisdiction, Lordship, and also by citing paragraph 112 of Muslim Mandal scale, Honorable High Court clearly states, Lordship, page Lordship 85, annexure, Lordship. Annexure H, Lordship, High Court's order, Lordship. And this scope page Lordship, High Court's order, para 112, Muslim Mandals, Lordship, I am reading, Lordship. The scope, ambit, and jurisdiction of a writ court in such matter has been discussed by the full bench of this court in State of Assam versus Muslim Mandal and others, reported in 2013 1 GLT 809. For a ready reference, the relevant paragraphs are of the said full bench judgment is quoted below, para 112. High Court judgment, Lordship. Annexure H, Lordship, my petition.
Acha, in our court. Okay.
Yes, Lord.
Yes. Annexure H. Okay.
Yes. para 112, Lordship, Lordship, it is in High Court judgment, internal page, Lordship, 5,
It's on page 5.
High Court
85.
judgment.
Yes.
The scope, ambit, and jurisdiction of the writ court in such matter has been discussed by full bench of this court in State of Assam versus Muslim Mandal and others, reported in 2013 1 GLT 809. For a ready reference, the relevant paragraphs are of the said full bench judgment is quoted below. 112, Article 226 of the Constitution confers on the High Court power to issue appropriate writ to any person or authority within its territorial jurisdiction. The tribunal constituted under the 1946 Act, read with 1964 order as noticed above, is required to discharge the quasi-judicial function. The High Court therefore has the power under Article 226 of the Constitution to issue writ of certiorari, quashing the decision of the tribunal in an appropriate case. The scope of interference with the tribunal's order in exercise of jurisdiction under Article 226, however, is limited. The writ of certiorari can be issued for correcting errors of jurisdiction as and when the inferior court or tribunal acts without jurisdiction or in excess of it, or fails to exercise it, or if such court or tribunal acts illegally in exercise of its undoubted jurisdiction, or when it decides without giving an opportunity to the parties to be heard, or violates the principle of natural justice. The certiorari jurisdiction of the writ court being supervisory and not appellate jurisdiction, the court cannot review the findings of facts reached by the inferior court or tribunal. There is, however, an exception to be said in general proposition, inasmuch as the writ of certiorari can be issued and decision of a tribunal on a finding of fact can be interfered with if in recording such a finding the tribunal has acted on evidence which is legally inadmissible or has refused to admit admissible evidence, or if the finding is not supported by any evidence at all, because in such cases such error would amount to an error of law apparent on the face of the record. The other errors of fact, however grave it may be, cannot be corrected by writ court. As noticed above, the judicial review of the order passed by the inferior court or the tribunal in exercise of jurisdiction under Article 226 of the Constitution is limited to correction of errors apparent on the face of the record, which also takes within its fold a case where a statutory authority exercising its discretionary jurisdiction did not take into consideration of a relevant fact or renders its decision on wholly irrelevant facts. Hence, the failure of taking into account the relevant facts or consideration of irrelevant factors which has a bearing on the decision of an inferior court or the tribunal can be a ground for interference of the High Court tribunal's decision in exercise of writ jurisdiction by the High Court. The apex court, para 113, the apex court in Santlal Gupta versus
But Mr. Sharma,
Lordship.
but still, except for the petitioner number 1, even if we accept your submissions,
Yes, Lordship.
save and accept this petitioner number 1, the other petitioners would still be entitled to some relief because there was no reference, separate reference made against them.
Yes, Lordship. But Lordship, I have seen the reference, Lordship. Earlier
Name of the
Yes.
family members are mentioned, but there is
mentioned,
no
Lordship,
reference.
but concerned Superintendent of Police, Lordship, directed the SI to make the inquiry against all the family members, Lordship.
But
There,
that's not there.
I think there, I have seen that.
No, but the reference is not available here in respect of others. When the matter went to the tribunal, the
Lordship.
reference is only against
And
Abdul
at that
Kalam.
time, Lordship, that settled law was not there, Lordship.
Still now we covered. On the last page of that reference, you will find that names of the family members are mentioned, and in the SP's letter, He's made reference against all.
Yes, Lordship. First, here, Lordship, first page of the LCR, Lordship.
Yes.
It has been seen and learned that Muhammad Abul Kalam, son of late Mujibur Haq, of village so and so, district so and so, you are therefore directed to start an enquiry immediately following all the provisions laid down in the IMDT Act 1983 and rules made thereunder, and submit a report through screening committee immediately superiors within a period of 15 days. Others persons' names are included, Lordship, in this direction, Lordship,
Still the
in this
reference is
order.
not there.
Then, Lordship, will kindly see the enquiry, Lordship, where in prima facie of this case, it appears that Muhammad Abul Kalam and his wife
No, because you see, unless a reference is made,
yes,
the
Lordship.
wife will not be able to show any document if she is not asked anything.
Yes,
Wife will claim for her own parents,
Lordship.
not from the husband.
But they have jointly filed the WS, Lordship.
We understand, but now, in view of the well-settled law,
Yes, Lordship.
at least even if we accept your submissions, we don't know whether we'll accept it or not, but even if we accept it, then still this reference against the others are not there.
Yes, in separate reference was not there, Lordship.
Can be sent back to the referral office.
নাই
Which
এইটো আব্দুল কালামটোৰ against to reference আছে ন তাৰটো মেৰিটত শুনিব লাগিব কমিটি মেম্বাৰ সেইটো একবাৰ সুধিব লাগিব আছে
Okay, we'll examine and pass orders.
Lordship, and Lordship, everything has been discussed in the High Court's order, Lordship. And Lordship, and Lordship, they are relying on a Gabra certificate during trial stage, Lordship. In present petition, they are not, they did not brought into notice this certificate, Lordship, and it was also not proved, Lordship. In present appeal, Lordship, they never mention about this certificate, Lordship. Some new documents collected, Lordship, there.
Mr. Sheikh?
My lord. My lord, regarding Abdul Kalam, my lord, that he has 71 voter list, my lord, directly produced before the tribunal. And your lordship, in additional affidavit, my lord, as I have filed as per direction of your lordship, Gambura certificate from Gamponsayat, my lord, your lordship directed that whether this person of certain village and certain village are the same person. To that, my lord, additional affidavit has been filed. So, my lord, regarding 1971 voter list, my lord, which directly contains the name of Abdul Kalam, my lord. So, my lord, that is not properly exhibited, but that has been considered by the learned tribunal.
Also,
It is
High Court also
rejected,
considered
my lord.
lordship.
It is
Third para.
rejected only on the ground that name is not proper. There
Village
is
is
some
also different
dissimilarity in name, my lord. And another thing is this, my lord, what my learned friend submitted regarding, my lord, this after opinion of the tribunal, those documents were obtained, my lord. That will not come in the consideration. That is my understanding, my lord. That cannot be considered. But what is there in the tribunal, my lord, it is not properly exhibited or it is rejected only on the ground of dissimilarity of names, my lord, regarding Abdul Kalam. My lord. And regarding others, my lord, your lordship already pointed out to my learned friend. So, my lord, my humble submission before your lordship that if a chance is given to Abdul Kalam to properly prove those documents, my lord, before the tribunal. My lord. My additional affidavit may also be taken into consideration. Oblige, your lordship.
Heard. Mr. M. Sheikh, counsel for the petitioner. As it is, all the counsel are there for respondents. Mr. Islam on behalf of Mr. A.I. Ali for ECI. Arguments are concluded, judgment is reserved.
I have handed over the LCR lordship that may be noted.
Uh, just write the next paragraph. Right, order dated 22/4/2025, comma, the no, order is 6/3/2025, comma, the records of the tribunal was handed over to Mr. G. Sharma and its standing counsel for the active matters for perusal and to address the court. First of the said records are returned today and kept with the record. In a short, they can come back.
Please, may I read lawsuit relevant portion?
This opinion
opinion is
No,
page
no, not you
62.
to read it, just tell us
Lordships,
the,
in paragraph number 2, Lordships, that is also important, Lordships. The reference is that the name of the opposite party was included in the draft electoral roll of 2005 under 25 number Bulagganj LSC at village North Kasokana at the time of house to house enumeration during the period from 1/10/24 to 25/24, and the electoral registration officer number so and so, having doubt about citizenship of the opposite party, got the matter verified by an on the spot local verification, and in consideration of the report of such verification, the ERO had reasonable doubt that the opposite party is not a citizen of India. According, the matter was forwarded to the competent authority for deciding the question whether the opposite party is a citizen of India or not. Thereafter, the reference was made to the police DW for.
where is the voters list of 1966?
Here I have in the WS stated that there was no verification, no spot, nothing else, and the inquiry report also totally blank, Lordships. That's why I referred this paragraph, Lordships. 1966 voter list is at page 27, Lordships.
Page?
Page 27.
27.
That is my grandfather's name and step grandmother's name. Page 28 appear. That is exhibit A. In my father's name in the voter list of 1977, that is exhibit B, that is page 29. My father's name is Sofiur Rahman. Along with step grandmother's name also appeared. And in 1997 voter list, my father's mother's name also appeared. That was exhibit E.
Just a moment.
Yes.
In this page 30, who is Sofiur Rahman?
Sofiur Rahman is my father, Lordships.
Page
Page
33, your
33.
father and
Father and mother.
yes.
And I also got this school certificate, that is page 18. Type copy is 18. And the vernacular is page 19. Exhibit F. School headmistress evidence. Also.
And whose name is that, page 33, sorry,
Okay.
34? Who is this?
33.
34.
34 is a photocopy lordship. It was not exhibited. Page 30.
This is not an exhibited document.
But it was annexed lordship. Photocopy. Yes, annexed are one lordship. Tribunal is the marked it lordship, the annexed are one is.
Is the date available when your father or mother expired?
The date is lordships 31/5/2019.
Who died?
Father died.
31, 30?
31/5/2019.
Yes. And mother?
And mother alive lordships. Now
Mother
I can say
alive.
at that point of, at the time filing, she was alive.
Mother did not come to give evidence.
No, lordships. But here I find, lordships, the exhibited documents, statement given but no findings is there, lordships. And my oral evidence, there is a statement, but there is no finding. It was not considered properly, lordship. And the exhibited document A, B, C, D, and F. F was rejected is on the ground, there is a state emblem on that ground rejected. But there, what is the oral evidence of my uncle is there, lordships, and my evidence, and school headmistress also had this evidence in this.
Where is the evidence of your uncle?
My evidence of my uncle is at page
DW
55,
two,
lordship.
DW two,
DW2,
Mohiuddin
Mohiuddin.
Ahmed. Is his name there in the written statement?
That was not written, lordships. Details family tree also I have given in my WS also, lordship.
Yes.
And his cross is at page 58, lordships.
58.
Page, DW2.
Yes.
I was born at village Belguri, part 1. I was born on 1/4/1948. Opposite party's father's name is Safiur Rahman of village Belguri, part 1. Safiur Rahman died on 31/5/2019 at Belguri, part 1. Mother of the opposite party is residing with her son Joimuddin at Belguri, part 1. The name of the grandfather of the opposite party is Ainullah Munshi. My name entered in the voter list of 1970. I am a regular voter. Grandfather of the opposite party is Ainullah Munshi was my uncle. Opposite party got married with Karim Bak Sheikh of Uttar Kasokhani. And evidence of the petitioner is evidence C48 cross 53. Type copy, handwritten copy is page 54, lordships. Petitioner's evidence is at page 53.
Just a moment. Set up করা নাই।
From that lordship, PW2, DW2.
What is the relationship between the proceeding and the petitioner and DW2?
Yes, lordships, uncles, but kindly see lordship page 20.
Page
My
20.
grandfather's brother is the father of DW2 lordship. That exhibit C it was lordships in the
Page 20.
page 20. For
Yes.
its sake, the father's name of DW2.
Yes.
And Ainullah is my grandfather.
Yes.
Both are brother lordships. So in the evidence DW2 lordships, his father's name here written Fariduddin Sarkar, Fariduddin, and lordship page 55 top fine lordships. Top affidavit first paragraph and paragraph 2 also it was clarified also lordships. Last line lordships, paragraph 2, page 55. The opposite
Page number?
Page 55.
55.
Lordship.
Yes.
Evidence of DW2. His father's name here also written. First affidavit, first I Mohiuddin, LI so either 70 years, son of late Fariduddin Sarkar, Fariduddin village so and so. And bottom in this page lordships, paragraph 2, bottom will find lordships, the opposite party's grandfather and my father are own brother.
Yes.
The evidences and documents are not challenged also. Other side not questioned it. Tribunal fails to consider lordship because no findings there is in the evidence or the oral evidence as well as documentary evidence. Only one in the exhibit F stated that in my linkage document school certificate, state emblem is there. That's why not considered. That cannot be a question lordship because the citizenship of a person concerned, because that issued by other whatever that they have been authorized to use the same, and headmaster also adduced evidence lordships in this case. Admission registrar also produced at the time of adducing evidence. And in respect of initial enquiry lordships, first enquiry I have annexed lordships that totally find blank except name of the petitioner. That is at page 68. On my WS, I have stated lordship, there is no verification at all. Never visited by residence also enquiry. I questioned the initial enquiry, also in WS page 43, paragraph 4. Tribunal stated that there is a spot enquiry. Page 43, paragraph 4, lordship will find.
Yes.
Lordship, regarding in blank inquiry, lordships, I will rely upon the judgment of this honorable court, lordship. 2022 Ford GLT. Page 102.
Name of the party.
Amina Khatun versus Union of India.
This is on what point?
Lordship,
On what point?
regarding blank inquiry, lordship, paragraph 6, 7, 8, 9, 10. I'm sorry to place one copy I have, lordships.
Lordship, this judgment has been distinguished also. We'll place that copy.
Blank inquiry.
So, to proceed to the other point. Why? 14. Yes, secretary. Two 2007. School 92. 91 of admit position. 91 of admit position, 92. Erase. 2014.
Yes.
And on the similar line lawsuits, two other judgment lawsuits,
Yes.
2023 4 GLT
20,
3 4 GLT 400 page 425 425.
yes.
Parties Pranita Hajong versus Union of India.
What is the name?
Pranita Hajong. PRANIK Pranita Hajong HAZONG Hajong versus Union of India and others. Paragraph 10.
Yes.
And another one is losses 2021 3 GLT on same line. 2021 3 GLT
2021,
2021 3 GLT
3 GLT.
page 12.
Yes.
Paragraph 8, 10, 11. Parties Sunakha, Elias Sunakhan versus Union of India.
Yes.
I'm sorry, I only have one copy losses, my copy also. This is could not get time losses for them. Whatever we can. So, website to website to
Yes, sir. But the positive says it, they're not there. He should be a record copy. But non copy. And because focus give certificate as well. He took a second. Yes.
Another, this of the regarding the inception of the case lawsuit, the foundation that is decided by the Honorable Affairs Court Lordships, it was decided on 11th July 2024. Civil appeal number so and so 2024, special leave petition, civil ID number Lordships 20674 of 2017. One copy I have, Lordship.
What is the name of the parties?
Name of the party is Muhammad Rahim Ali versus Abdul Rahim. Versus State of Assam. Muhammad Rahim Ali alias Abdul Rahim, appellant versus the State of Assam and others.
Yes.
One copy to Lordship, the long judgment, some of the paragraph, may I read, Lordship? It will convenience for this court, Lordship.
You have referred here, paragraph 23 to
23, Lordship.
to
Yes.
27,
Lordships.
33 to 37, 30,
Lordships.
39, 40, 41, 42.
Lordships. It's
Then
very
44, 45, 46, and 54.
54. Very important paragraph to say. Regarding, if Lordship permit me, may I read, Lordship?
No, not required.
Lordships. And regarding
Because this judgment has been placed before us and
earlier
n number
occasions,
of
one of
times.
the case I also placed, Lordship.
N number of times you have read this.
Lordship. One times I have placed, Lordship.
Yes, yes.
And regarding non-consideration of my oral evidence, Lordships, I am placing the reliance of this honorable court, Lordships. Two 2022 3 GLT page 816.
Yes.
Korimali versus Union of India. Paragraph 12, 13, 14, 15, 16, 17, 40, 51, 52, 53, 54.
Whose judgment is it? Who made this judgment? Huh?
Yes.
What is she saying?
If Lordship permit, may I read?
Yes, we've seen that.
Lordships, another judgment of this court, Lordships, 2021 GLT 330. 2021 GLT 330. Parties name Motiur Rahman versus Union of India. In this case, regarding evidences are not challenged, not refuted, Lordships. That's reflected in paragraph 8, 9, 11, 12.
2021 GLT, page
330.
page 2 box
330.
330.
Yes.
And similar putting Lordships regarding non-challenging the evidences. 2013 1 GLT 941.
2000.
13 1 GLT 941. Paragraph 9 and 10.
Party. Party na?
Party Abdul Khalik versus Union of India. This is the writ appeal, Lordship, division bench judgment.
Yes.
And another one on same footing, Lordships, evidences are not challenged, that is 2013 1 GLT. Vicinity. Abdul Khalik. Sorry, Lordship, I will provided this.
Okay.
And in respect of Sarvando Sonwal, Lordship, aware of that. In this case, petitioner has detailed family history has been given, date of birth, everything. And in the writ petition, I have annexed, Lordship, in respect of NRC draft list, Lordships. That is also final draft list, subsequently they publish. My father's name, mother's name, family members appeared. My name appeared but rejected because of that, since the debutar case is there. That I have annexed, Lordship will find. Lordship, presumption can be drawn that the petitioner is the family of that. That's Ainullah Munshi and Sakir Rahman, Lordship. Others have since
Which page?
That is page, Lordships. My writ petition. Page, Lordships. I have annexed, Lordship, page 73. Type copy. Next page is the computerized copy, Lordships. My father's mother's name is there. Page 73 is the type copy. Next is the computerized copy, Lordship. And my name will find, Lordship, page 75, serial number 3. Rejected because of DVD. Debutar defective. Computerized copy is at page 76.
Okay.
Tribunal Sonwal, Lordship, same time, Lordship, aware of that, paragraph 50, 55.
Paragraph.
Tribunal Sonwal, paragraph 50, 55, 56, 60, 61, and 62. This is Tribunal Sonwal, 2 Lordships. 2007 1 SCC 174. Since other familiars, Lordships, and evidence also not been challenged, Lordships, here is my linkage document. Here is the school certificate, and even now I produce next Lordship, the writ petition NRC also, Lordship. My humble submission that may kindly be considered, Lordship, or matter may remanded back to give a proper findings against the evidences, Lordships.
Okay. We'll continue to
Lordships.
Number 6, my lord. My lord, I have been informed just my lord, parents father had died, my lord. So I have to go to Navagraha, my lord. So if your lordship permits, my lord, any other day, my lord, you think this week, my lord.
6 adjourned after 2 weeks.
I'll oblige, my lord.
Lordship, can this matter be kept parted and fixed next week, the one which we were doing now?
Got to do it next week.
Just now, this matter, item 3, Lordship.
Thanks.
I'll have to collect some citations which are there in the office, Lordship.
Okay, then we'll fix it on 8. The submissions of Mr. F.U. Bormier and counsel for the petitioner is concluded. Reserving right to reply. Next para. All the respondents are represented. On the prayer made by Ms. A. Verma and standing also for the FT matters and NRC. On the matters stands adjourned today. List on 8/5/2025 as parted matter.
I
Yes.
hope Lordship will give us some indulgence and hear our matter today. Because I'm seeing Lordship has got some very major matters that are being heard in detail. So we are here. Lordship had kept that APSC batch today and tomorrow. Just hoping it starts.
Okay.
I'm great.
But Mr. Sharma, you're there. Just look at the records. I've seen there's an office note with regard to the
Sealed cover.
inquiry report being placed. That I could not lay my hand on.
My information, Lordship, is subject to correction.
No, it is the record says it was placed before the court.
I think it was returned thereafter.
But I don't know.
So we will get that instruction before because I remember that was the final report, which resulted then in further suspensions and charge sheets, etc.
That I won't be able to say.
I'm only just updating Lordship because I'm handling most of it, but we will assist Lordship at that time. Dinesh.
Just check up from the records. If required, just give them the records.
Great.
APSC matters. Seal को आसे नहीं की कैसे? Oh, it is okay. Okay, it was kept in secret place. It has come.
Sealed cover.
Seal cover is there.
Great.
Okay, it's available.
That may have some relevance because that is in continuation of the last hearing.
Okay. Well,
Lordship, it was said the court has taken note of the report and the same is directed to be kept in seal cover under the custody of the Registrar Judicial. This was, Lordship,
that's fine.
The order of 29th of September last year.
We are aware of it since it was not there in the record. We just
grateful.
Now they have got it. Okay. So then we take up this matter. Then we take up the APSC matters then.
We may have to tell the other side. So maybe Lordship may wish to do at least one matter in between. We can call the other side also.
Okay. Yes, item 5 then.
Please, Your Lordship. My lord, the petitioner has collected some more documents of her grandfather, my lord. So, my lord, those records are vital documents, my lord. So, 3 weeks time may kindly be granted to file additional affidavit, my lord, to place these said documents, my lord.
After 5 years, you remembered that.
My lord, they have collected recently, my lord.
Can you tell us these documents are of which date?
My
Any
lord, said documents are of the year 1965, my lord. Then, my lord, it was 1960, my lord.
If you collected, do it within 10 days.
Just 2 weeks time, maybe.
That'll be too long. You see, it is a 2020 matter. You have 5 years down the line from the date of filing. If you have collected it, file it.
Well.
Your name
Hussain.
on the prayer made by Mr. J. Hussain, learned counsel for the petitioner. The matter is adjourned today to enable him to file. We just say matter is adjourned today. Just on, give a date after 10 days. We're giving a date after 10 days, but we're not saying, we're just adjourning on your prayer.
14th of May. বিচাৰিজন নাছিল এতিয়া বুজিছো স্যার নেমি 14 to 16 that's what it was. নাই নাই কৰা
Item 7.
Okay. I'm paying on behalf of S. Chakraborty. He is under Lexing court number 2. Let me kindly pass over for time being.
Item 8.
Now the appears on call for the petitioner. All the respondents are represented. For ends of justice, the matter stands adjourned today. Next, in the event the petitioner default continues to make default in appearance on the next date of listing, adverse orders will follow. List after 2 weeks.
Item 9.
মাতিছো
May I please your lordship, item number 8.
টাইম নেমটো হেৰি কৰে ল'ব ৰিফ্লেক্ট কৰে লোৱা নামটো হেৰি কৰে লোৱা
Item 9.
He is appearing for item number 8.
If you're there, we'll take it up.
Lordship, in 1965, Exhibit A, grandparents and father of the petitioner enlisted in the voter list of 1965. Annexure 5, page 45. Grandparents and father.
Yes.
In 1970, grandparents, brother of the grandparents and father name enlisted in the voter list of 1970. Exhibit B, page 47.
This
yes,
annexure 5 is exhibit number. Page 45, you have shown us. This is exhibit number
Exhibit number A.
A.
Lordship. 1970, grandparents, brother of the grandfather, father name enlisted in the voter list of 1970. Exhibit B. Page 47.
I'll go to
1979, grandparents, parents, and uncle of the petitioner enlisted in the voter list of 1979. Exhibit C, at village Utkati.
You are at page 47.
Lordship, but in the said voter list, the age of the father of the petitioner wrongly recorded 4 feet. Instead of
No,
56.
you are at page 47 earlier. Page 47 is voter list of 1970.
Lordship.
You are related to whom in this voter list?
Ding, village thing.
No. You are related to which person in this voter list? Page 47 you had referred earlier. Voter list of 1970. The people whose names are entered here, how you are related to them?
Abdul Khaled, grandfather.
Yes.
Abdul Khaled, grandfather, and Solomon is a grandmother. Abdul Salam, father. 1979, page 49, Lordship. Grandparents, parents, and uncle of the petitioner.
Just a moment. But you see, there's no explanation in either your written statement or your evidence on affidavit. You see, when you are introducing your grandmother at page 48, her age is compared to your grandfather, look at her age. Correct. Now, this is 1970. Then you come to 1979, which is at page 50. If you can just market this therapy, you'll be filthily rich. You look at this, and then there's a change in the village.
Lordship. Lordship, shifting, the family of the petitioner previously resided at village Thing. Later on, they shifted residence of village Thing to Utkati.
Was it pleaded in the written statement or in the evidence?
Written statement, page 15, Lordship.
Was it
Clearly
pleaded?
stated.
Was it pleaded?
Lordship. Page 15.
Yes.
Paragraph 4 and 17.
Paragraph 4 gives a place of residence. Shifting is not mentioned.
17, Lordship, page.
17.
Paragraph 17, page 17.
Okay.
Lordship, in this case, DW2 Gaubura also examined and Gaubura issued certificate in favor of the petitioner, Lordship.
Which page is that certificate?
Certificate page 18, page 76, annexure 18.
Page
76.
77, but this becomes inadmissible.
Lordship, Secretary of Utkati, PDP also issued certificate in favor of the petitioner. Secretary also. Lordship, 2005, petitioner name appeared along with his father. Gabura. DW.
Only two witnesses. But then you fail in your endeavor to prove anything. Please come to this page 82. You see, in your written statement, you give a make a statement that from Ding he shifted somewhere else. Now, you project the person at serial number 6, Abdul Khalek, Pita Ainuddin, as your father,
Grandfather.
grandfather. Okay. So from grandfather, what is the name of your father?
Abdul Salem.
Abdul Khalek.
Salem. Salem.
Salem.
Salam.
Abdul Salam.
Grandfather Abdul Khalid.
Abdul Khalek. This existence of Abdul Khalek is in the voter list till when?
1965, 1970, 1979, 1965, page 45. Serial number 550.
That means, as per your documents, Abdul Khalek was dead in 1985. That is at page 52. Correct. Now this reference against you, you'll come to page 32, reference against you by the Superintendent of Police was on 28 January 2008. And thereafter comes this mutation order, which is of 1910-2020. 1910-2020 is after the date of the opinion of the tribunal. Tribunal opinion is 26/8/2020. So this mutation order comes later on. And this is in light of your written statement saying that from Dhing you had shifted to
Utkati.
yes. Incidentally, these two places would be about 35 to 40 kilometers away. Because even if we overlook this discrepancy of the age or otherwise, but still documents may connect to show that this,
Lordship, 2005 petitioner name appeared along with his father.
where is that page?
Page 59. A Salam 266 serial number. And petitioner 270 Amir Hussain.
Your father was alive till when? Till which year your father is available?
Two 2016.
Is there till at least 2015?
Lordship. Lordship, page 65 legacy data. Petitioner grandfather, father and uncle name also appear.
Unfortunately, in your evidence or in your written statement, you don't present your family together. They are all disconnected. Page number?
Page 65.
65. So if you don't know your family from your readings,
2005. 59.
Lordship,
No, no, she is not yet completed.
yes.
Yes. How is the opinion bad according to you?
Lordship, discrepancy of age. Learned member did not consider the voter list because of discrepancy of age, Lordship. Learned member also wrongly held that the petitioner did not produce any land document to prove the residence of his father, but in fact petitioner exhibited the land document of his grandfather as exhibit L and M.
But you see, that was discarded because of the fact that this exhibit L was not in the name of Abdul Khalik. Exhibit L is a copy of Jamabandi.
Lordship, serial number 10, Abdul Khalik.
Please come to page 68. Serial number 10 can't be read.
Missing but origin record is there, Lordship.
No, incidentally, that is the part which we can't read even in the trial court record. It is at page 104.
Subsequently, I issued this money to obtain.
You're right. Being. Words in scholar.
No, because now you'll have to produce the same document which you produced before the tribunal. This is a copy which is obtained in 2020.
After.
And that, yes, and this is a document which you presented before the tribunal. The certified copy was obtained on 87. So the tribunal's judgment is based on this document, saying that Abdul Khalik name doesn't appear in this. So to find out any perversity, we'll have to look into the same document and find out, not a new certified copy. You'll have to get it. We give you a week's time, you get it.
No, 104 Lordship. Page.
104, we can't read that entry. That entry we can't read. Unless you say you have read it. Have you read it? No.
That is why we advise the petitioners.
No, but we can't look into a document which is new. How this entry has been made, we don't know. We'll have to only see the same document which the tribunal saw and discarded that the name is not there. Because we'll have to find perversity, not our own original satisfaction on the documents. Because we are not examining the documents.
I should kindly see Exhibit M. Again, Damabandi copy, page 72.
Exhibit M.
Lordship, page 72.
No, you bring it, we give you 10 days time, you bring that document. You see, when a document was exhibited in original, that means the original has to be there. You can't say you don't have the original one. So we are giving you time, you produce it. In course of submissions, Ms. A. Hussain,
A.
learned counsel for the petitioner, has referred to entry number 10 of page 104 of the tribunal's records. First of how the said entry could not be read. Next, therefore, grant 10 days time to the petitioner to the petitioner produce the original document.
Lordship, 15 days.
Hmm?
Lordship, 15 days. Maybe
15 days, okay. 2 weeks time to produce the same. Produce the original of Exhibit L. List on 19/5/2025. We are returning you this document.
Lordship, kindly see Exhibit M.
Come to it, we are adjourning it. Produce the document, then we will hear it. But you have done better.
Lordship, item 11, kindly fix next week. Item 11, kindly fix next week.
Item 11, after a week. Next time, be more prepared.
Upgraded item 14 to 62 for hearing.
So the Pankar Nath's office, we duly informed Mr. Diganta Das and Mr. Ken Chaudhary and some of the councils. Lordship would like, till they come, I can just give a background without making any arguments. Okay. This. In fact, in this batch, Lordship, way back in 2020, Lordship had declined stay. So there is a detailed order by Lordship, in fact, declining stay in this. That's of 21st of October 2020. Against the learned single judge's final judgment of 18-3-20. May I just give the overview of the facts? I'm not making any arguments because they have to open it. But to save on judicial time, Lordship, they've impugned the petitioners the final judgment of the learned single judge of 18-3-20. In the lead matter, there was writ petition 4198 of 2019. Gitali Dole. The issue actually begins with the FIR 936 of 2016, which was filed on 27th of October 2016 in Dibrugarh.
We have a list of dates anyway.
We haven't made it, but we'll give. If Lordship would hear also, I'll make sure we give it to you. We'll give it tomorrow if Lordship wants it, not a problem. I'm only giving an overview of facts, not making an argument. Lordship, what had happened is, and Lordship may not know, we will give these dates. What had happened, one Anshumitra Gogoi, she was the complainant and she claimed at that time that she had been approached by a gentleman saying that give me 10 lakhs and we will help you pass the APSC matter. Yes, I'm only giving facts in the background because nobody was there. I thought we'll save some judicial time. So, as a result of that FIR, there were several arrests. That's good.
I'm just, no. I'm just appearing in one of the cases, in this age. I mean, they came earlier occasions also. Or other senior judges, D. Das, K. Chaudhary, they also made the lead arguments. And there is one case of mine where on last two occasions and this time also I am going to, there are some distinctions factually which I will point out at the appropriate time. That will be my role, not the main argument. Unlimited of can be.
No, but then somebody must begin.
Of course, Lordship.
Somebody might begin. I don't know.
I'm in almost at the moment playing the role of an amicus of giving facts without making a submission.
It will not be proper for me if I make the lead argument today. Actually, I am not making it. My case, my only submission is that this case here is factually certain single judge's orders, judgment. Roped in, my lord, and factually this case is slightly distinguishable. To that limited extent only, I'll be here to argue.
So if nobody begins, you go by default.
That's why I am present. There are my lord, lawyers learned more than me who are leading, my lord.
No, we don't know. We can't find a parameter. We would be
Maybe-
very happy if you can give a parameter.
Maybe they are.
How to assess who is more
Some of their
learned.
juniors are-
Learned is learned. There's no, what you call, superlative to that.
But it- there is a- I remember
We don't have learner, learned and learnest.
I have, of course, chosen glorious silence because I said there's a dangerous zone to get into.
No, that's okay. Give your facts.
I'm only
Let
giving
him-
the
let him
facts
give it.
as a background. So what happened, Lordship?
Today it will not be. I don't think if everybody.
Otherwise, tomorrow morning, if Lordship were keeping it early, I'm sure everybody would come.
Everybody will.
Well, it is naturally, they are pursuing the case in fairness. They may be on their legs also because the matter has come.
I just finished the Parhat matter in the other court and then I rushed to this court.
Right, Mr. Barabuya, in fact, who came in the morning also. He thought I might be mentioning. So, Lordship, what had happened is that this FIR of Dibrugarh of 27th of October 2016, Lordship, resulted in a series of arrests of middlemen and then prospective candidates, Lordship. Now, Lordship may just note, this relates to two batches. This is the 2015 batch, Lordship, who cleared the exam in 2013. So, Lordship, 2015 batch of officers who cleared the exam in 2013. And Lordship, so basically 2013 exams, they are the batch of 2015. There were 45,000, this figure is important, Lordship, 553 people who appeared in the preliminary examination. And finally, 2,287 appeared in the mains. So they are the ones who finally cleared the mains, interview, etc., and made it to the 2015 batch. Similarly, those who sat in 2014, they are part of the 2016 batch. Approximately 1,550 people appeared in the mains out of 24,722 who appeared in the prelims. In the first 2015 batch, 471 people were called for the interviews. 497, Lordship. And 241 were selected. In the 2016 batch,
241 out of
497. So, Lordship, the figures are 45,553 sit for the prelims, 22,287 sit for the mains, 497 are called for interview, 241 are selected. In 2016, 24,722 sit for the mains, 1,550 for the mains, 22,722 for prelims, 1,550 for the mains, 371 called for interview, and 180 selected. So therefore, Lordship, 421 people are selected in the two batches. This is all given in para 3 of the impugned judgment, Lordship. 421 are selected in the 2 years, which is the 15-16 batch. And originally there were 52 petitioners before the learned single judge. And those 52, Lordship, translate into 31 from the civil service, Assam Civil Service, 11 from the police service.
Please give it again. Out of 52 petitioners,
31 are ACS, civil service, 11 are APS, 6 are taxation or revenue, taxation department, 2 are transport, 2 are labor. 4, 10. This is all part of the judgment, but I'm just giving basic figures because these are the, as we say, just basic facts.
I missed out. After taxation, you said 2
Labor.
labor and 2.
So transport. So so primarily, Lordship, the bulk is from the civil service, 11 are from the APS, and then 222, and 6 from taxation. Now, Lordship, what came out through the investigation was a modus operandi, which quite created a furor in the state, because it was a very evolved modus operandi to rig the examination process. how it was done was that the candidates who paid a certain sum of money to the touts. So this involved the APSC chairman, that time Mr. Rakesh Paul, who stands now convicted also in one of the cases.
8 years.
He was in fact he was in custody for 8 years, and his bail had been consistently declined by this court and the Honorable Supreme Court on a number of occasions. So last year, I think the court has finally given him bail because he has also completed a substantial part of that his conviction. Lordship, so what was the modus operandi? That the chairperson had a set of, I will use the word touts or middlemen, either employees of the APSC or otherwise, who would then contact prospective candidates. A fee was fixed ranging from about 10 lakhs to about 35-40 lakhs, depending on the service which was being targeted. Then they went and gave their examination as normal candidates. After they gave their examinations, it went to the strong room of the APSC. Thereafter, these candidates' papers, which is the examination answer sheets, were taken out from the strong room. They wrote examinations again on duplicate answer sheets because the brother of the APSC chairperson, who has been absconding throughout this period, also had a printing press. It is believed he went off to Nepal. So these answer sheets, they would again write. Fake signature was done of the invigilator. In some cases signed by Mr. Paul himself. And then this final revised answer sheet was replaced into the strong room, and therefore they rigged the system and got selected into the service. It was a detailed investigation. There had to be a forensic audit also, check everything investigation, so that the signatures could be seen, everything could be seen. That all was done. And finally, Lordship, they were all discharged. And I will give you the rules under which they were discharged, Lordship. They were discharged, this is all given in para 4 also, but Assam Civil Service Rules, Rule 20C.
This all 241 plus 188.
Yes.
Yes, Lordship.
All of them discharged.
Yes.
All were discharged. No, Lordship.
Selected.
No, I'm talking of the selected, Lordship. Selected are 52. Out of them, not all are discharged.
Okay, 52 are all discharged.
Yes, Lordship. Because this is finally what the single judge has upheld is the discharge.
Discharged on?
Different dates, Lordship.
Okay.
But now I will make the legal point after this. Lordship, so ACS, the concerned rule is Rule 20C. Assam Civil Service Rules, Rule 20C. Then police is Assam Police Service Rules 1966, Rule 16B. Assam Taxation Service Rules are of 95, Lordship. Ladyship may note also. Rule 19.2, Roman 2.
Just a moment. Assam Civil Service Rules is 20C.
Yes, Lordship.
Then-
Police 1966 rules, police service. Rule 16B.
Yes.
Then Assam Taxation Service Rules are of 95. Rule 19.2.
Yes.
Then Assam Transport Rules are of 2000. Transport Service Rules are of 2003. Again 19.2. And finally, Assam Labour Service Rules of 2007. Which is Rule 13C, Lordship. Now, the most critical point, Lordship, is they were all probationers. This is the critical point, Lordship. So they were all probationers. I'm giving the facts. I don't want to argue because it is not fair. So, Lordship, they were all probationers. And second point is, there was no letter of confirmation in any of their cases. Now, Lordship, only for the law. The legal point is there are three legal points or the series of judgments which will cover the background now. In such cases, Lordship, of fraud in examinations, this is not new, Lordship. It has taken place in schools, it has taken place in college, it has taken place in recruitment over several states. Haryana, Punjab, many states, Bihar. So, Lordship, the general rule or the ratio of the series of judgments from the high courts up to finally the Supreme Court has been the principle. If you can segregate the grain from the chaff, then the whole examination is not to be scrapped. This is the ratio settled law. And if you can segregate the grain from the chaff, which means identify the beneficiaries, then you take action with the beneficiaries and don't scrap the entire examination. How this has evolved, Lordship? Because an argument is made by those who are non-tainted, bona fide people who have sat for an exam, that why are you now keeping us out of the process when we have got selected on merit? And in fairness to that argument, Lordship, sometimes people don't make it in the second attempt. So this is how it has evolved, particularly from a line of judgments from the Punjab side. So this is the legal principle on examinations. Now, in this particular case, Lordship, a lot had happened in that period. PILs got formed, a one-man committee got formed. These are all separate strings of the whole thing. There was also a question, should the government scrap the entire process or should it go for the identified beneficiaries? Since there was an investigation that identified who were the so-called tainted candidates, they were discharged from service. So therefore, they are probationers, no letter of confirmation. Now let me again give Lordship and Ladyship one second legal principle deals with the probation and confirmation in service. In that, Lordship, in confirmation, Lordship, there is the concept of the deemed confirmation. That if you are a probationer, the governor does not give a positive notification of your confirmation in service, you can't be treated as a probationer through your entire service life. So the concept of deemed confirmation comes in. Now, Lordship, this has also evolved into the settled law that first, a positive confirmation is a must. In the absence of it, there is an upper limit ceiling when you will have to take it as a deemed confirmation. And the final judgment that came to this at that time was Justice Chandrachud's judgment, which says that if you have an initial period of probation, it may be 2 years, maybe 3 years, and if there is a period of extension within the rules, then your deemed confirmation will come at the end of the extended period. So suppose you are in service as a probationer for 2 years. If 2 years more are provided in the rules for extension of that probation, then after 4 years, there's a concept of deemed probation, deemed confirmation. In this particular case, no one could cross the threshold of deemed confirmation. Because here in the rules, it is 2 + 2. And they were discharged within that period. Thank you. Right, Lordship. So that's on the concept of deemed confirmation. The third principle, which was again argued, is, Lordship, on the principle of whether they will be the beneficiaries of Article 311 and the protection therein. So the question that arose is, what is the argument was, this is a taint at the entry of the service. It is not a misconduct during the service. So this has been the other area that the learned single judge has dealt with. I'm not arguing which side has argued what, Lordship. So I'm just pointing out. So there is the issue of deemed which has taken place, confirmation. There is the issue of the police investigation which has been dealt with. Then there is, Lordship, the argument in terms of when does the service conduct rules apply per se. On all of it, Lordship, relying on a huge plethora of judgments from both sides. I have to say, we also gave a compilation. We still carry the same compilation of 4 volumes. But Lordship, quite the law is very interesting also because of how it has evolved. Finally, the learned single judge was pleased to uphold those discharge. And in that, Lordship, today we stand. Several of them have appealed, not all of them. All have? I stand corrected. All have appealed. Now, Lordship, what is relevant is one order in the appellate proceedings, Lordship, is the order of 21/10/2020. And I'll request Lordship, Ladyship to see that order. Then I will be, after that order, bring Lordship and Ladyship to the what transpired thereafter. So when the matter came up, Lordship, obviously they were agitating for stay. Yes, Lordship. 21/10, Lordship. 2020, Lordship. So this is towards the end of the first COVID period. 21/10. 21st of October 2020. Stay application.
Interlocutory application was main writ petition.
IA.
In the IA.
In the IA, Lordship.
It's supposed to file.
Shall I give my file? Yeah, but just for it's only 45. So I'm only factually pointing out that stay has been declared as early as 21st of October 2020. While it has no relevance because we are at final, but I'm only completion of the basic one. And after that, I'll just make 2 more developments for the SIT and all that. I'll point that.
It's just like buck stops here.
That's why. So, Lordship, it came before Lordship. It has traversed Guwahati High Court's several courtrooms. It is before Lordship once again. Of course, Lordship will excuse, I mark my file because we always mark what we may think is relevant.
Definitely, you can do whatever you want to do with your property. So long as it is yours.
Last one. I got one. Wait for some. सबने फाइल किया ना? हाँ, हम सब सारे हमारे रिप्लाई प्रॉब्लम है। I'll take only 10 minutes. So now, Lordship, subsequent to this, several hearings have taken place. Matter has not been heard, and we are grateful that Lordship said that we'll keep it 2 days. At least it will gather some momentum, Lordship. what happened during one of the arguments, Lordship, at that time before the then Chief Justice, Justice Mehta, an order got to be passed, an argument was raised in one writ petition. This is also relevant because that SIT is formed and that Lordship was asking about that. That background is important. What had happened, Lordship? During the investigation, when the police had raided the then chairperson, Mr. Rakesh Paul's residence, a 9-page tabulation sheet was found. Now on that, Lordship, a lot of notes were made in the hand, marks had been changed, and that also came as part of the investigation. And this was maintained by Mr. Rakesh Paul. Stay wala, wo nikalna SIT ka formation. In that, Lordship, one argument in the appeal was raised during hearing that time. In fact, that is the appeals that Mr. Diganta Das, learned senior, he argued that. He argued about these challenge. He challenged the investigation by saying, and also the outcome of the investigation by saying the state acted against a set of people but did not act in the same alacrity against the others who were named in the 9-page. So this was the crux. I mean, that was part of his arguments. We had our point to say, Lordship, but I'm not getting into the arguments. In context of that, Lordship, on 29th of September 2023, this is a relevant order, Lordship. And again, if it's not in the file, I'll share my file, Lordship. 29/9/2023. We've seen that, Lordship has seen it. So, Lordship, in that an SIT got formed, and then some terms of reference or queries from the court flowed, which are recorded as point 1234.
You see that?
Yes, Lordship, I'm grateful for that. Then, Lordship, subsequent to that,
because here too, both sides, I have a query.
Yes, Lordship.
I would like both sides to make submissions on that. Because you see, this is intra-court appeal. We have our own limitations. Examine that. Or the decision by the learned single judge. Then, by virtue of this order, we are getting additional material. So what is the scope and ambit of an additional material, though passed by the orders of this court, to be examined at the final hearing? That's the issue which both of you will have to address.
And I'll happily address that. In fact, I'm very clear on it from day one. Is that absolutely, Lordship, because ultimately what has to be seen is whether there is an error or a perversity or an incorrect application of law in the learned single judge's judgment. And what has been assailed is that judgment. So therefore, what has to be seen are the arguments that in a way would satisfy Lordship and Ladyship's conscience whether there is a need to interfere in that order or not. And second, Lordship, I may also point out that the people who get identified in the 9 pages and on whom the SIT report has come are not even the petitioners here. That is the critical point.
Please repeat again.
This is the critical point. Though the SIT report does not relate to the petitioners herein. I'm sorry, the appellants herein. The original
Definitely, because this is with regard to those persons, because it's that any disciplinary action against the left out officers.
Exactly. So this is a separate set of people who are agitating their cause separately. I may point out that charge sheets have been filed in several cases against all those people. So it was an Article 14 argument. It is not an argument within the scope of this appeal. Because this appeal does not deal with any of the people that the SIT has looked at further investigation on. All the appellants herein stood discharged. As of today, Lordship may also note that the trial is on 9th of May is the next date in the trial, Lordship. And Ladyship may note that 27 witnesses stand examined in the trial. against these set of appellants. That's the critical point. These are the background facts, if I may say, Lordship, Ladyship, and that I have assisted the court, not as the respondent, per se. I choose my words as per se, Lordship. Now, subject to, of course, Lordship's indulgence and acceptance.
Just a question, this special case 6 of 2017 or Dibrugarh police station case number 936 of 16, the investigation is still continuing.
Trial. It's on, trial is on.
Trial is going on.
27 witnesses examined against the current set of appellants.
When was the charge sheet filed?
This is the exact date. In fact, I had requested my colleague. Lordship, please, no, that's for the new law. We'll tell you, Lordship, the exact dates. In fact, I request, oh, there, Mr. Chaudhary.
I'm so sorry, because I was on arguing a matter in court number 2.
So I must only point, I would have given facts, not an argument here.
No, it doesn't matter.
So, but Lordship, to answer the question, I'll give the dates. The charge sheets were filed. Where we stand is with the appellants is trial had started, charges were framed, 27 witnesses have been examined. They are continuing. Now, what has happened, Lordship? There were a series of charge sheets filed, supplementary charge sheets. The latest ones that got filed were charge sheet number 12, 13, 14, which is after the SIT and does not deal with the appellants. And these are between January and September 2024. So supplementary charge sheet 12, 13, 14, between January 24 to September 24 as an outcome of the SIT against several other people, not the appellants. So prior to charge sheet 12 up to the 11th supplementary deals with the appellants. 27 witness examined. And Lordship, one more fact I must just say, there were 2 FIRs. One was Dibrugarh. Subsequently, there was an FIR also Bhangagarh police station. But Dibrugarh is the main FIR in our case. In Bhangagarh, the conviction of Mr. Rakesh Paul happened. But I must just for completion of facts point. And that basically dealt with agricultural development officers, not the appellants of the services that I pointed out to Lordship today. In fairness.
When you use that word, you have to also explain. You meant notes or your notings.
কেস করবো নয়, তোমাকে উল্টা পাল্টা কি পড়া? I'm sorry, Miller. Petition খন দিয়া। My lord, basically, our case is, we were probationers. And we were discharged from service.
You are making submissions on in which
My lord,
items?
basically, my lord, I'll appear in, I'll give the numbers, my lord. My lord, in today's cause list, item number 17, 18, 24, 27, 31, 53, 61, and 62. My lord, 62 is a case not belonging to this category, my lord. He is in fact has been convicted by the criminal court, my lord, and he's in some agriculture development officer. But he is not a civil service officer. So I think this matter can be detached, my lord. Item 62. So I'm appearing in 17, 18, 24, 27, 31, 53, and 62. 61, sorry.
62, you say is agriculture officer, it
Yes,
can be
yes.
detached.
And he has been convicted by criminal court. His criminal appeal is pending, my lord. I don't think this is relevant. This is not the same batch. It's a different case.
You're not covered by the single department.
No.
Please check it out.
It pertains to another police station case also. It's a different matter.
It's okay, since he's appearing, let him check up and then, because once we detach again.
Yes,
there
I
will
have
be-
only checked. It may be the Bhangagarh police station. Bhangagarh. But I need to just check whether they are part of the.
That can be done.
That's all.
It's
Okay.
Yes. Now, my lord, our basic case is we are provisional. Now, as a
Just a moment. Those other matters in the list relating to foreigners, they will not be taken up. Yes.
Yes. So, my lord, since we are provisioner, if you want to discharge by a simple order of termination, it's okay. But what the authority did, my lord, they took note of some misconduct. So the moment misconduct is taken note of, then it assumes the character of punishment. In which case, my lord, Article 311(2) becomes imperative. That is our basic case. Oh, সেইটো ক'ত? এই paragraph 2 পৰা দেখাব লাগিব নহয়, item number. এই হেৰি petition to appeal to দিয়াচোন। এই deposit বঢ়াৰ বিলটো কোনটো নাম্বাৰটো? Deposit বঢ়া। পালা? My lord, otherwise, my lead case would be item number 17, my lord. Rumi Saikia. But for a particular affidavit, I'll rely upon, my lord, item 27.
So.
28 নম্বৰটো দিবচোন।
27, what's the name of it? 27 name of the deposit.
My lord, in item number 27, that is writ appeal number 131 of 2020, my lord. There, my lord, the affidavit filed by the state is annexed. By mistake, my lord, it was not given here because I'll file earlier in point of time. So there I'll show, my lord, the state stand. There I'll rely upon para 7 at page 125. Vale? Ahorita que es lo que pasa.
I'm not saying in favor of citizenship, so if you believe that. That's why it's not.
Second half. तो बन जाते हैं। Milord will kindly come to page 125, Milord. That's the affidavit filed by the state.
Just a moment.
Yes,
My
sorry.
sister will get the file.
Yes. File two.
No, it's a separate two
I'm
blocks,
sorry.
and therefore from one block, they have got me first, then they are now looking for my esteemed sister's
Right, sir.
brief.
Certainly.
In fact, this is good. We also get clear which affidavit we can.
Only these two, no other.
In the single judge, we had relied on one, Kunal Das, and therefore taken that as the lead matter and argued. So a lot of things we refer to are to the affidavit and what we did in Kunal Das. The rules, everything.
There's no difficulty. Only thing is for our convenience, we are relying on that. Eventually, it boils down to
Same issue. So I was only saying, in all probability, Lordship, I'll end up arguing from Kunal Das because we've annexed in that compendium compilation all the rules, everything.
Very good, very good. My lord will kindly come to page 125, para 7 on top. This is the common stand of the state in all the cases. Page 125.
Yes.
Where the Honorable Justice Nandi has got. Yes. When the information was received by the department in respect of a concerned ACS officer, and the same was verified from the report submitted by Dibrugarh Police in June 2018, a conscious decision was taken to invoke provisions of Rule 20C of the Assam Civil Service Rules, 1998 in short, to discharge the concerned officers from the service. It is stated that the foundation of the said decision was based on informations received which constituted just and sufficient reason to believe that concerned officers were ineligible or unfit to be a member of the service. It is further clarified that while taking such a decision, state respondents were not interested in ascertaining the truth or otherwise pertaining to culpability of the concerned officers in the matter of their selection. The decision to discharge them from service was taken in public interest for maintaining probity in the matter of public employment. Well, what is clearly evident is the satisfaction as is mandated in Rule 20C that he is unfit to be retained is derived from a police report. Am I clear, my lord? So whether this satisfaction can withstand judicial scrutiny, that is the question. Now, my lord will kindly rules for copy diya. Whole program. Yes, hey, rules kon ase na? এইখন কিতাপত দিয়ক না এইখন কিতাপ আছে না My lord, now I'll refer to 20C. Photo list condition of book list. সেইখনটো থাকিব লাগে তাতো পেজটো নিমিলিব না My Lord, Assam Civil Service Rule 1998.
No.
My Lord, Assam Civil Service Rule 1998.
Here it is in page 33.
এখন নীলাখন নেকি হ'ব তাতো চবতে আছে Assam Civil Service Rule 20C. Lord, we can hand over one copy for her lordship's. My Lord. 20C, my lord. ACT Lord, 20C.
We have it.
A member shall be liable to be discharged from service. Please come to C. If any information received relating to his integrity, age, health, character, and antecedents, the governor is satisfied that probationer is ineligible or otherwise unfit for being member of a service. So, my lord, in my humble understanding, what Rule 20C envisages is the governor has to record a satisfaction. Now, whether a police report or an information in the case diary can be said to constitute an information based on which the requisite satisfaction can be derived. And my humble understanding is no. The moment you take note of any wrongdoing or misconduct, as we normally say, then, my lord, 311 is attracted, in which case you have to hold a regular departmental inquiry. Now, as far as the impugn order is concerned, my lord, the order of 125 into file of page 95, my lord, is the order. Page 95, 20th June 2018, Governor of Assam, in exercise of the power conferred by Rule 20C of the Assam Civil Service Rule, is pleased to discharge Srimati Rumi Saika ACS Probationer, Assistant Commissioner Gulaghat, under suspension from service with immediate effect. So, my lord, this is the order.
$95 of the same brief.
Of writ appeal number, item number 17, my lord, na? Writ appeal number 101 of 2020. That will be the lead case where I will be arguing, my lord. Photo to this, na? Item 7. Itu diyo.
My lord, I'll respectfully submit, lordship may take the paper book of item 17, my lord. I'll be arguing in that case.
17.
Into ACS, in ACS, to
As is an amount. Foundation to lay for the. Page 95, my lord, is the order.
Just a moment, my sister will get the file.
As far as the files are concerned, we will not trouble your lordship now. We'll confine to this.
Here, there is no difficulty. The difficulty starts when we make it CAV.
Correct.
Then we have to deal with it. We are the boss and we are the server.
Okay, sir.
And then to find out if you don't write it perfectly, then to trace out the document becomes
Very difficult.
very difficult. So, my lord, now these are the basic facts. We have completed most of the trainings and all because of the Dibrugarh police station report. My lord, we are discharged. And actually, we are appointed on 12/8/15 as a provisioner. And the impugn order was passed on 26/18. And in the meantime, my lord, almost all the requisite trainings were also completed. Interim order is advertised করবো না লাগে তো আসে না নাই নাই আচ্ছা হেরি অর্ডার তো খুব বেশি আমার এনকেস না এনিওয়ে এটার বাকি yes yes now my lord let me articulate my arguments. Live streaming off. Okay. My lord, tomorrow I think lordships will be having some part one matters also. So, my lord, Because if we
both have agreed, is it possible, my lord, if we start at 2 o'clock?
No, 2 o'clock. It's okay because once we break it, it's very difficult to
Correct.
again have it. We have outstanding outstation benches and then all
In fact,
this.
lordship, just as a procedure, subject to lordship's convenience and ladyship's convenience. Tomorrow they will continue. What I'm also going to request is I will take my arguments after they have completed all the.
Yes. My lord, tomorrow if I get 2 hours, I think I should be able to complete.
So, and then lordship, what I would again, I'm here tomorrow also, lordship. If lordship is taking it Monday, Tuesday, whatever, I'll join on VC then. from Delhi. But for my arguments, I would prefer to come physically because I find it's more, it's better from the court's perspective, better from my perspective also to be
Yes, yes.
physical than do a very long argument on VC. It does not have the same. I don't think Lordship, many things get lost in the VC according to me in final years.
Sometimes,
My colleagues don't agree because my colleagues are of a different generation.
No,
but I am very
sometimes
old.
what happens, I agree with my learned friend. We need to know the demeanor of the honorable courts also, my lord. How courts are reacting to our argument.
And in fairness, Lordship, I think when we argue ourselves, standing on your feet, and there's something I think is very different about the way you argue.
And secondly, my lord, when questions are falling from the bench, then we
That
can
means-
appreciate, oh, this is the point.
That means our expressions are readable.
Not always, my lord. No, my lord, what happens when a question comes, then we get to know, my lord, that we need to answer this also. But that is not possible in VC.
Yes,
Should I continue, my lord?
yes, 10 minutes, we can
Okay.
continue.
I'm sorry, my lord. I thought lordship.
I just asked because
Okay, no problem, no problem. My lord, I would like to articulate my points in the following manner, my lord. I'll of course come up with that. In fact, in my written argument before the single judge is already there. If allegation of misconduct is the basis / foundation, then Article 311(2) is attractive. If allegation of misconduct is the basis, then Article 311(2) is attracted. There is a second dimension to this limb, my lord. If the charge is based on misconduct, or if there is a live connection between alleged misconduct and the charge, DP is imperative. If the charge is based on misconduct, or if there is a live connection between the alleged misconduct and the discharge, DP is imperative. Second is, my lord, there cannot be an abstract proposition of law that a simple order of discharge can never be punitive in nature. Merely because, my lord, the language is couched in a very simple language, it is not innocuous, it is not always suggestive of the fact that it is not punitive in nature. Even though
but
it
at times it's very difficult to understand. You see, I'll just tell you a concept. For example, people who are to be weeded out after their service, let us say 50 years, 52 years, FR 56, 58,
Great,
50,
great.
60. There, the ACRs, all the ACRs are evaluated. And then a satisfaction is arrived at that this man is a deadwood. Now, if in a discharge order, somebody writes that he's a deadwood and therefore discharged, then you say it's a punitive order because there's a attachment of a conduct in that order. If it is not written, then also we have repetition saying that the discharge was made, order simply cited, nothing was explained why I was discharged.
That is very simple. Supreme Court has explained in subsequent judgment. If in the process of finding out whether one is suitable or not, in that process, you can do that. But you cannot undertake that exercise to punish somebody.
It says it cannot be a shortcut to
Yes.
disciplinary proceeding.
Yes. In
No,
the
but
process
how
of
will
suppressing,
how will the order be written? You see, we received writ petition on both phases. Both facets say one says that, well, you have recorded satisfaction and therefore it's you have arrived at some sort of charge and therefore you are discharging me.
FR 56J, in my humble understanding, it stands on a different,
No, we understand, but
pedestal
you see
altogether.
how that's why I'm posing this question.
Question is, here in this case, it's an open and shut case. Here we need not even trouble so much to ourselves, because here they are relying on a police report. And that police report is yet to see the light of the day. As a statements under Article 162 only, nothing more. And what does the Evidence Act say? You can't even rely upon it. It can't use it against me. So, my lord, if in the process of finding out whether I am suitable for retaining or not, in that process, if you find I am not suitable, then you pass a simple order of discharge, that is understandable.
Can I ask a question?
Yes.
Now, let us say there is a person who in his private conduct, nothing to do with official business, he is arrested for some offense, let us say voyeurism. He is arrested and he's a probationer. So the employer says that, well, you have been arrested in that conduct. Based on that police report, we don't find you suitable for this extension of probation and therefore we discharge you. Will it be so bad?
It will be bad because you are relying on some misconduct, on some certain allegations. The moment allegation is there, there has to be an inquiry. And not the law is
No,
very clear.
inquiry will be only with a fact which relates to his service. It cannot be
Even for his personal conduct, my lord. End of the day, my lord, as an
if
employer.
it is not permissible.
No, my lord, as an employer, what can be questioned? His conduct as an employer. No, my lord, sometimes what happens, a moral, ethical part is also there. Therefore, there are Supreme Court judgment where it says that at times it may be taken note of because it's the employer's discretion. The Supreme Court has not said in absolute terms, but there are, my lord, case laws, I think, where it says even those aspects also can be taken note of. Not merely because it is not in the course of employment. It can be. But the moment you take note of an allegation, then, my lord, an inquiry is imperative. That is my understanding of the law as laid down by the Supreme Court, right from Purushottam Lal Dhingra till date. That 1958.
Yes.
So, my lord, therefore, so even if the words are used in a very innocuous manner, it may not be suggestive of the fact that it is not founded on any allegation. Then the third proposition is, my lord, the third proposition is Rule 20C can be invoked on account of the grounds enumerated in Rule 20C. To that extent, there is no difficulty. So, two sub-proposition follows. One, this satisfaction is always justiciable. That means it is the duty of the respondents to place before your lordships the records of the case as to how that informed decision was taken. The idea is whether relevant considerations were taken note of or not, or whether any irrelevant consideration has been taken. In other words, consideration adjournment alone be taken note of. And the second aspect is, my lord, this satisfaction can be derived only on proof facts, not on hypothesis, not on suspicion. Now, police report is not a proof fact. Criminal trial is going on. Nothing has happened till date. So there is a presumption of innocence until proved guilty.
But that would lead to a proposition.
Huh.
Let us say a person is caught red-handed for some offense.
Yes.
And then the probation period would expire, let us say 31st May. And he gets what you call, when it comes to a police report, issue of theft, then trial and all. So the probation becomes the period over, he becomes a permanent employee. And 10 years later on, when the trial is over, he is found guilty, then the position back to that today 1st May position cannot be arrived at. He is already person who is confirmed in service.
Yes.
Because then
No, not. My lord, somebody is arrested on account of some charge. That by itself is
No, but because here it
enough,
says,
my lord.
no, here it says that his conduct.
Yes.
So his conduct can always be seen that a conduct, impeccable conduct in the office where he is working, and otherwise also an impeccable conduct.
Difficulty in this case is, my lord, they are correlating our misconduct to a stage when we are not even recruited. Therefore, whether 20, that would be my other argument. Whether therefore 20C could at all have been attracted, that is another question. They are trying to say our entry into the service itself is bad. Because when we unfold the argument, my lord, this will develop. So therefore, that is another leap. So I was, my lord, on the other point, that
You are on invocation of Rule 20C.
Yes, yes.
And therefore record should
and
be
it
placed
can,
before the court.
it can be done only on proof facts. Then, my lord, my fourth proposition is
In this last third proposition, you said there were two facets.
yes, first
You-
facet is, my lord, it has to be just it is justiciable. That means, my lord, they are bound to place the record before your
Yes,
lordships,
that's one.
and lordships will examine whether the requisite satisfaction as mandated by 20C was arrived at or not. And second limb is, my lord, what are the materials? And in my humble submission, it has to be proof facts. It cannot be based on any supposition, ifs and buts. Some proof facts. Then, my lord, my fourth proposition is, as per section 25 and 26 of the Evidence Act.
But in this aspect,
Yes, my lord,
please come to page 111
of the
of your the same file.
paper book, my lord.
Yes.
Yes. Yes.
Now,
Prayer, my lord.
yes,
Huh.
the prayer, I'm asking you this because you see now we are at the appellate stage.
Yes.
If under the prayers, the record and the satisfaction of the authority to before discharging him were not called for,
No, it was called for.
it was called for.
Yes. It was called for. Our case is, my lord, it was not properly appreciated.
It's okay.
Yes.
Then
It was called for. It was produced. Yes. No, it's not that for the first time I am saying, we are on appeal, my lord.
no, I'm
Yes.
asking it because the prayer of the prayer.
Yeah,
I am
yeah.
conscious of the prayer, and therefore I'm asking.
Yes, yes. Then, my lord, my fourth formulation is, as per section 25 and 26 of the Evidence Act, any statement made before the police is not admissible in evidence. Now, only document based on which we have been discharged is the case diary of Dibrugarh Police Station. Now, my lord, in the Bhagalpur blinding case, that is Khatri, 1981 to SCC 493, TC Khatri, the question cropped up as to, in a 226 or in an Article 32 or a 226 proceeding, whether such statement or such report would be admissible.
But in that case, if you are referring to the Bhagalpur blinding case,
Yes.
that was a offense. The persons charged for a criminal offense
Yes.
of blinding a person in the police station.
Not on several, yes.
Several. That's the main point.
Uh,
Once you see this, just look at this
No, no, what
Evidence Act.
what I'm trying to
In
submit
the
is, my
Evidence
lord,
Act sections, when you are referring to section 26
yes.
or 27, that relates to trial of an offense.
No. Yes. So therefore, now we are in a 220. I'm coming to the second limit, my lord. In a 226 proceeding, what would be the value of such police report or police statement?
Yes.
That is the issue. Now, there my submission is, my lord, as Supreme Court says, such a material which is admissible in evidence, that alone can be taken not within a 226%. In other words, somebody must present himself for cross-examination, then thereafter, my lord, some legitimacy can be given. Merely because something is written in the case diary, that is not a material for that purpose. So basically, these are my four, points which I'll broadly argue.
We'll continue tomorrow then.
My lord, fine.
At 2 o'clock.
My lord, deep lord.
Since there are several senior counsel and counsel in the matter, the court master will circulate a paper. Please write the names so that it can be incorporated in the order.
My lord.
I think by tomorrow we'll also get a sense from the other in terms of that would be a little bit from for us also a possible.
And please indicate the case numbers.
Yes.
Of course, we are in all.
No, it's for the appellee because.
Yes.
this is-
As far as my cases are concerned, just now will be.
Yes.
Okay.
No, because you may not like to be named for item X where you are not there. So that's why.
I give the list now.
Yes, it's okay.
I'm deeply obliged.
No, just a moment. I'm
I'm
under
sorry.
house arrest till my secretary comes.
That's why I didn't move. Also, Lordship, that's quite an oxymoron for you to be sitting there and saying you're on house arrest.
No, that's a fact. The day we were elevated. That is why now after my elevation, I understood why they call the appointment orders at warrant. I got no other explanation.
It's a warrant.
Yes. You have no freedom at all. You go to a movie, somebody is behind you, watching you.
Lordship, there is also that thing in public life. There is no privacy.
So far as I am
No,
concerned,
at least-
in item number 2, my lord, I think.
No,
there
I will
is a
just
number-
circulate. Your instructing counsel's name has to be given. Please ask them to write it because otherwise it will be difficult to dictate. One name another. You forget, huh?
In item number 2, I think I will join the argument for the petitioner side after the main arguers finish, my lord. He being one, I think there is one more thing under that. And my case only I will take not more than 15 to 20 minutes. My case is slightly distinguishable, even with regard to the policy.
Okay.
That will be my submission.
That's so. The submissions of Mr. K.N. Chaudhary, Ranit Senior Counsel, remains duly instructed by his instructing counsel remains inconclusive. Stop. List the matter again as parted on tomorrow. Second.
2 p.m.
We are not writing 2 p.m.
Yes,
just-
I understand.
Please understand.
Deeply obliged.
Just in the morning, remind me, we'll fix it at 2 o'clock.
BA 2656 of 24.
Made clear.
Yes.
Here in this case, Lordship, the petitioners are in custody since 8/5/2022. And I have filed one additional affidavit, Lordship. Here to raise one more plea that at the time of arrest, they were not informed about their grounds of arrest, Lordship. And in the arrest memo, your Lordship will find at page 97. Although there is a column that grounds of arrest and it is written as sufficient evidence found against him. Apart from that, no other particulars has been mentioned to him as to how he is involved in the case or other materials also. And similar to other accused also. So, may I please that this mentioning the grounds of arrest is lordship that is also the right to mention about grounds of arrest derived from Article 22(1) lordship. So may I read that Article 22(1) first lordship?
What was it?
22(1). Protection against arrest and detention in certain cases. No person who is arrested shall be detained in custody without being informed as soon as may be of the grounds for such arrest, nor shall he be denied the right to consult and to be defended by a legal practitioner of his choice. So that grounds of arrest has to be informed to the arrestee. And now that similar provision appears in the CRPC, that your lordship will find section 50. And now it is in New Act, it is 47. Section 50 of CRPC. Now, as the case is under NDPS Act, so I am taking your lordship to the NDPS Act, section 52, lordship. Wherein also similar provision is there, lordship, in NDPS cases.
NDPS Act. That's it. NDPS Act. Narcotic.
I am handing over a book, lordship. (52)(1).
Yeah, easy to civil like this.
Yes.
Now, lordship has seen that Constitution, CRPC as well as NDPS provides us almost similar provision. Now, the question is lordship whether that how that has to be communicated to the accused and in what manner. Lordship. For that, lordship, I am relying on certain judgments of Honorable Apex Court, lordship. Just I am handing over that compilation. Lordship. Lordship may first take up that Bihan Kumar's case. It is in the first page 1. So that paragraph 14, your lordship will find that article 22-21 has been discussed. Paragraph 14. In my compilation, page 14, 12, Lordship, paragraph 14. And last 4 lines, I'm just reading that part. On the failure to comply with the requirement of informing grounds of arrest as soon as may be after the arrest is vitiated. Once the arrest is held to be vitiated, the person arrested cannot remain in custody even for a second. That part. And now that this will also apply to NDPS cases. That also your Lordship will find conclusions, page paragraph 21, Lordship. Conclusion, and all those are there just for to whether for NDPS purposes. Lordship may kindly see that F. When a violation of Article 22(1) is established, it is the duty of the court to forthwith order the release of the accused. That will be a ground to grant bail even if statutory restrictions on the grant of bail exist. And in NDPS case, section 37 is there. Therefore, this observation I am pointing out. The statutory restrictions do not affect the power of the court to grant bail when the violation of Article 21 and 22 of the Constitution is established. Now I am coming to the grounds, Lordship. Lordship has seen in the arrest memo, it is written that sufficient grounds found, Lordship. So whether that will amount to informing the grounds or not, for that purpose, Lordship may kindly turn to paragraph 26 of the said judgment, Lordship. May I read, Lordship? The stand taken before the High Court was that the appellant's wife was informed about the arrest. Information about the arrest is completely different from the grounds of arrest. The grounds of arrest are different from the arrest memo. The arrest memo incorporates the name of the arrested person, his permanent address, present address, particulars of FIR, and section applied, place of arrest, date and time of arrest, the name of the officer arresting the accused and name, address and phone number of the person to whom information about the arrest has been given. We have perused the arrest memo in the present case. The same contains only the information stated above and not the grounds of arrest. The information about the arrest is completely different from the information about the grounds of arrest. More information of arrest will not, mere information of arrest will not amount to furnishing grounds of arrest. And regarding this also, Lordship, that in Probir Purkasta's case, that is elaborately given that in the second judgment, it starts from page 21 of my compilation. Lordship may kindly see, I'm placing paragraph 37, Lordship. In Probir Purkasta case, what is written there, that is quoted in that paragraph. And those regions, difference between regions and grounds of arrest, Lordship, that is elaborately discussed in paragraph 48 of that Probir Purkasta judgment.
Paragraph?
Paragraph 48, 37 and 48. And whether that has to be in writing or not, that your Lordship will find paragraph 45. regarding informing in writing that paragraph 19, 30 and 45.
In the same judgment.
In the same judgment also.
37, 48 is for?
37 and 47 regarding difference to show that reasons for arrest and grounds of arrest are two different things. And that has to be in writing. Oral information will not do. For that purpose, Lordship, that other paragraphs.
What, para 30?
Yes. Paragraph 19, 30 and 45, Lordship.
On what point?
That information, that communication has to be in writing regarding grounds of arrest.
Yes.
And then I'm taking your Lordship to page 51. Lordship, may I kindly see Ashish Thakkar case. Here, page 52 is the 52 is relevant paragraph where I'm relying, Lordship. From middle portion, Lordship, may I read?
Yes.
We are inclined to consider only the last issue raised by the appellant with respect to the non-furnishing of the grounds of arrest. Upon perusing annexure P3, we can see that what has been provided to the appellant is only an arrest memo in the prescribed format in which is meant to be given to the appellant by way of an intimation. It has been filled up with the name of the appellant along with the place of arrest. Additionally, it has been written that he has been arrested based upon the statement of the co-accused. Similar to my case, here also it is said that you have sufficient evidence found. We are in agreement with the submission made by the learned senior counsel appearing for the appellant that the said arrest memo cannot be construed as grounds of arrest, as no other worthwhile particulars have been furnished to him. And as in the present case, charge sheet is submitted, so I am I am placing reliance on also paragraph 21 D at page 15 of my compilation, that mere filing of charge sheet will not validate the initial remand which is illegal also. And in paragraph 56, Lordship, I have given one division bench judgment of our High Court. Page 56. In that case, Lordship, the person was arrested. Subsequently, he was released on bail and he challenged his arrest because no information on grounds of arrest was communicated to him. And even then, Lordship, this Honorable Court passed an order and cancelled the PR1 executed by the petitioner, Lordship. So that coming belatedly, that may not be a bar for the petitioners to raise this issue at this stage, Lordship. And in the Bihan Kumar's case also, in D, where I am saying that that we are filing of charge sheet will not validate the initial remand. There also one observation is there that even the courts, Lordship, held that initial remand is illegal. That will not, Lordship, hamper the trial also. So that during trial also that plea can be raised, Lordship. One line is added that needless to add that.
You are reading where?
Page 15, Lordship. Page 15, Bihan Kumar's case, Lordship, paragraph 21. Clause D.
Paragraph?
D, 21D. And C also that it is burden of the prosecution to prove that they have complied. It is the prosecution's burden.
Yes.
Another coordinate bench judgment I have given, Lordship, where, Lordship, it is held that it is mandatory. And even at belated stage also that was considered and granted bail, Lordship.
Which one?
From page number, from page 59 onwards, Lordship. Page 59, your Lordship will find. 59. relying on those Bihan Kumars and Prabir Prakash Bihan Kumar. Except the judgment which is from 64 to 73, others are on of NDPS cases. Lord. None of the documents which was furnished to the accused or to his family members, those grounds were not mentioned. And in Ashish Katkar's case, your lordship has seen that even though it was mentioned that co-accused has implicated, that also Supreme Court said that worthwhile particular has to be there. How he is involved, how these suspicions arise, that necessity to arrest. That part has to be there. In Prabir Prakash case, paragraph that I have referred, paragraph 48, clearly says that the necessity to arrest, that part has to be there. Paragraph 48. Just one line I am reading of him. This from paragraph 48 and page 49. These reasons should commonly apply to any person arrested on charge of a crime, whereas the grounds of arrest would be required to contain all such details in hand of the investigating officer, which necessitated the arrest of the accused. So he says sufficient grounds, but those were not disclosed.
Yes.
And one observation, although that is not very much relevant to decide the issue, but I'm placing to your lordship that page 50 of Prabir Purkasto's last observation of the Honorable Apex Court, paragraph 52, though you would have been persuaded to direct the release of the appellant without requiring him to furnish bonds or security, but since charge sheet has been filed, we feel it appropriate to direct the appellant that the appellant shall be released from custody on furnishing bail and bonds to the satisfaction of the trial court.
Yes.
Even though it was a challenge after filing of charge sheet, so just consider. In my case also, charge sheet is submitted. And considering that aspect, lordship may consider the application for bail. In Bihan Kumar's case also, it is said that even though statutory restrictions exist, and it is seen that Article 22(1) is violated, that can be a ground for bail even though statutory restrictions are there, lordship. And the grounds of arrest column which they have filled, that sufficient evidence are found and not disclosing the same, that has violated that Article 22(1). That
Yes.
What my learned friend had stated, it is true, Lordship. If we look into the under section 50 of the CRPC, Lordship, that is 8522 dated, Lordship, their grounds are not there. But on the similar, however, I want to state here, Lordship, on 7/5 dated 7/5/22 under section 50, that is on the previous day, Lordship, 7/5/25, 7/5/22, grounds need not be ground, Lordship, but why he was arrested in the context, Lordship, it is there. Lordship may look into that, Lordship.
Which one?
Article under section 50 of NDPS Act. I have flag mark, Lordship.
Of the NDPS Act.
And not, Lordship, in the records, Lordship. One notice is there, Lordship.
we have also enclosed, your Lordship, will find in the affidavit page 98.
No, there, it is there. Under CRPC, I'm not talking about CRPC. Yeah, it is. What I can say, not.
In the record,
Lordship.
section 50.
Section 50 of NDPS, Lordship. I flag mark. I have also stated that section 50 of NDPS. It is for search, Lordship, but still. Because in Bihan case, Lordship, it is not of NDPS case. It is not of special. In that case, Lordship, no kind of arrest memo was given to them, Lordship, at all. Not only ground of arrest, nothing is there, Lordship.
Yes.
Lordship has gone. More.
Yes.
Yes, Lordship, may only also go through, Lordship, section 54 of NDPS. NDPS contribution. NDPS section 54. It is there, no, Lordship. It's section 54. Presumption from possession of illicit article. May I read, Lordship?
Yes.
In trials under this act, it may be presumed unless and until the contrary is proved that the accused has committed an offense under this act in respect of first A, any narcotic drugs or psychotropic substance or controlled substance, that, Lordship, and at the last point, Lordship, last line, for the possession of which he fails to account satisfactorily. And in this case, Lordship, in his house, which is both they are brothers, Lordship, and they lived in the same house. And this 262 grams of heroin were found there, Lordship. So it is, why this is in their possession, it is their duty to satisfy, they fails to satisfy, Lordship, then presumption will be against them. It is true, Lordship, I accept also that, Lordship, grounds of arrest need to be there. But in Bihan case, when a person is red-handed, Lordship, it has not, it is gray area is there, Lordship. In my humble opinion, Lordship. That gray area is there. Because they know that it is in their house only, Lordship. So in my opinion, they know about that. They are already know, Lordship. And if we look into the section, under section 50 of NDPS Act, at the same time, Lordship, on day before, 7/5/22, Lordship. Why all the things are going on, Lordship? So they are communicating in my humble, Lordship, submission. It is also true that they need to be known, but they are red-handed, Lordship. They in their house, these things are found, and according to section 54, presumption is also there, Lordship. In their house, it is presumed in trial, Lordship, in trial. So it is a bit, it is not gray area is there, Lordship, in the judgment. In my little knowledge, what I have, Lordship. It is not clarified in the Lordship. Moreover, regarding materials, it is already there, Lordship. 2 times rejected. Earlier 2 times rejected, Lordship.
So here, if your Lordship permits, I will verify 2 aspects, Lordship. First, Lordship, that he said that the NDPS cases this will not cover. That already I have referred to that Procedural case, that paragraph 19, that covers, Lordship, that any other offense. That in that case also UAP and PMLA was there. In there also that statutory restriction is there. And in paragraph 21F of Bihan Kumar's case, it is already there. And the second thing, Lordship, what my learned friend, that paragraph section 54, that relates to in trial. And I am that initial remand. That initial, that grounds of arrest were not communicated at the time of arrest.
How many witnesses are examined till now?
So far, I have annexed, Lordship, that annexer five.
I think 5, Lord.
Out of?
Out of 10.
Out of 10. And one more aspect, Lordship, why this is required that at the time of arrest, they should be aware about those grounds. Because your Lordship will find in page 88, the one of the co-accused was granted bail that because during trial, the witnesses said that he was brought to the place of occurrence subsequently. But from the FIR forwarding and the prosecution case, your Lordship will find that these 3 persons were there, from their position it was recovered. So it is apparent from this page 88 that there is some manipulation in the records, Lordship. Page 88, that co-accused was granted bail, and the witnesses who came to court, they said, Lordship, that this person was brought to the place of occurrence subsequently. Because of that reason, he was granted bail. So now the case of the prosecution.
Page 68.
88, Lordship. 88. So that they cannot manipulate documents or the case. Therefore, Lordship, this protection has been given to the arrested persons, Lordship. They should comply with it. And in failure to do so, that accused will get the benefit. Paragraph 5 of that order, your Lordship will find.
Within the compound. Within the compound.
Council.
Council is also within the compound.
So whether they have placed those things in the cowshed or something else, if the grounds are communicated to them, they could have informed the police, Lordship. But nothing was disclosed to them in writing. So therefore, my humble submission is that when the constitutional and statutory rights are violated, Lordship, these petitioners are entitled for bail. That is my humble submission.
Yeah, examine possible.
Obliged, Lordship.
আমি কেন বসে কি বসে কে দাস
Item 2.
Your Lordship, this rule is prepared for modification, Lordship, at page Lordship 30. The 11% of the judgment is page 33, Lordship. There are 9, 10, and 11. This order honorable court directed us to pay the ADR salary with interest, lordship. But there is a settled position of law, lordship, which Annexer D, lordship, in case of ADR salary.
Yes, what is the ground of review?
Ground of review is, lordship, there is a settled position of law, lordship, that ADR salary cannot be claimed more than 3 years, lordship. It is I have annexed the judgment, lordship, passed in Harendra Chandra Nath case, lordship. Relevant portion at page 40, lordship, annexer D, paragraph 3.
Page?
Page 40, lordship.
40.
Yes, lordship.
Yes.
May I read para 3? It has been averred in the writ petition that the similarly situated persons were given some benefit with effect from the date of their joining. In other words, even though the writ petitioners were entitled to get the actual financial benefit from the date of their joining, but by virtue of other order dated 10/12/99, the actual financial benefit was only given from the date of order that is 10/12/99, and the pay was fixed in the scale of pay of so and so, notionally from the date of their joining. It transfer a petitioner appointed on consolidated fixed pay per month. The similarly situated persons who were initially appointed as undergraduate pay teachers were given benefit of the regular scale of rupees so and so from the date of joining in post of undergraduate teachers. This is their case, lordship. Honorable court, lordship, has decided, lordship, on the basis of Honorable Apex Court's order, para 6, 7, and 8, lordship. Para 6, it is stated, the similarly situated undergraduate teachers got benefit of regular scale of pay rupees so and so by order date so and so, and the petitioner from the first time approached this honorable court in the year 98 and thereafter in the year 2000. Disputedly, there was long delay in filing the writ petition. In this regard, perhaps the writ petitioner might contend that where the issue relates to the payment of the fixation of salary or the allowances, the challenge does not become stale by limitation of the doctrine of laches, as the denial of benefit occurs every month when the salary is paid, thereby giving rise to a fresh cause of action based on continuing wrong. As such, the impugn direction of the learned single judge cannot be held good. Paragraph 7, lordship, the apex court on consideration of M.R. Gupta versus Union of India, as reported in 1995, 5 APSC 628, and Union of India versus Tarsem Singh, as reported in so and so, re-enunciated the law regarding the doctrine of laches. Lordship, I have bring this lordship, and lordship, here para 8, we cannot agree where the issue relate to payment of fixation of salary or the allowances. The challenge is not barred by limitation or the doctrine of laches, as the denial of benefit occurs every month when the salary is paid, whereby giving rise to a fresh cause of action based on the continuing wrong. Though the lesser payment may be consequence of the error that was committed at the time of appointment, the claim for a higher allowances is in accordance with the rules prospectively from the date of application, cannot be rejected merely because it arises from a wrong fixation made several years prior to the claim of the correct payment. But in respect of grant of consequential relief of recovery of arrears for the past period, the principle relating to recurring the successive wrongs would apply. Therefore, the consequential relief of the payment of arrear will have to be restricted to a period of 3 years prior to the date of original application, lordship. This is my case, lordship. And lordship, we could not place before writ court, in the earlier writ petition, we we were absent on that day, Lordship, due to our other, we were in other courts, Lordship. British Standing Councils were absent, Lordship. We could not place the settled position of law before your honorable court, Lordship. This is my humble submission, Lordship. And Lordship, it is also stated by apex court, Lordship. I have bringing my judgment, Lordship. Can I place? And Lordship, thereafter, authority also verified as per other directions given in this judgment, Lordship. We have verified also, Lordship. I have placing all the relevant judgments before your Lordship. Paragraphs also I have written above of every judgment, Lordship. Tarsem Singh, Lordship. Tarsem Singh, 2008 SCC. 648, Lordship. Para 7 and 8, Lordship.
You have a copy of that?
Yes, Lordship. All the copies I have given, Lordship. Union of India versus Tarsem Singh.
Tarsem Singh.
Yes, Lordship. Para 7 and 8. Here also 3 years period is mentioned in para 7, Lordship.
Please pass on that Tarsem Singh.
Yes.
Tarsem Singh case, please.
I have provided. Muy fine.
Asim Singh, paragraph?
7 and 8, Lordship. 7 and 8, Lordship.
Right. This is R. Borobora, General Counsel for the petitioner. Petitioners. Next paragraph. This revision, this review petition has been directed against the order dated 23/3/2023 passed by this court in WPC 183 of 2016, whereby the petitioners were directed to pay arrears salary of the petitioners with effect from 31/10/1997 within 3 months from the date of receipt of the certified copy of the order, telling which the amount would carry interest at the rate of 9% after expiry of the said 3 months. So, however, comma, but it was also directed that the Director of Education, comma, BTC could make an inquiry within 2 months as to the correctness of the claim of the petitioners and of the writ petitioners that they have been working uninterruptedly after 12/11/2004 till date. And if found working, comma, payment of arrears shall be made within 3 months. Next para. The learned counsel for the petitioners has submitted that the writ petitioners claimed their arrears salary with effect from 1997 by filing a writ petition in the year 2016, and therefore, on account of delay of 19 years in approaching the court, comma, the principle of delay defeats equity would be applicable. Full stop. Accordingly, comma, referring to the following cases, comma, the learned standing counsel for the petitioners has prayed for review of the said order dated 23/3/2023. Next para. After this order, was any contempt petition filed? When?
Contempt petition number, Lordship.
You have referred to this petition
Yes,
as page
yes.
21, contempt petition 663
Yes, Lordship.
of 23.
23.
Stop.
Paragraph 6. Lordship.
Okay. It appears from the statement made in paragraph 5 of this review petition that owing to non-compliance of the order dated 23/3/2023, comma, passed in WPC 183 of 2016, comma, the respondents herein no, the 41 out of 50 writ petitioners in WPC 183 of 2016 had filed a contempt petition, which was registered as cont case C number 633 of 2023. Next paragraph. The facts of the present case is found to be different from the facts on which the cases cited by the learned counsel for the review petitioners. Full stop. In the case of M.R. Gupta, the the appellant before the Supreme Court of India, after joining fire service, after 11 years of joining service, approached the Central Administrative Tribunal for proper fixation of his pay as on the date of joining the railway service. Partly allowing this said appeal. Now, the Supreme Court of India has observed that the fixation of the fixation of pay was a continuing wrong, and therefore the same was liable to be considered. However, the question of limitation was applied with regard to the consequential and other reliefs, including arrears if any, was held to be considered for being considered and decided in accordance with law by the tribunal. Next para. In the case of State of Madhya Pradesh and others, Yogendra, Yogendra, Yogendra Srivastava, SHRIVASTAVA. There also, it was held that the issue relating to payment or fixation of salary or any allowance would not be barred by limitation or on the doctrine of wretches, as the denial of benefit occurs every month when salary is paid. And therefore, denial of benefit occurs every month when the salary is paid, giving rise to a fresh cause of action. And only insofar as the arrears are concerned, the respondents were found entitled to recover the difference in NPA only in regard to the salary which accrued during the last 3 years prior to the date of filing of the original applications. Next, in the case of Tarsem Singh, within bracket Supra, the arrears were ordered to be restricted to 3 years prior to the date of filing of the writ petition. So in the case of Ratan Chandra Samanta, SAMMANTA, and others, or the issue related to re-employment. And therefore, as the casual laborers, comma, fail to enforce their rights except by sending a vague representation, comma, the absence of any fresh cause of action was held to have remedy lost by lapse of time. Next, in the case of Khogendra Chandra Debnath, Supra, the claim for revision of pay scale from time to time was made after 40 years of their initial appointments, for which relief was denied to them on ground of delay and laches. Next, in this case, in hand, it is not in dispute that the borderland it is called Borderland Territorial Council, BTC or BAC?
BTC, Lordship. Earlier it
BTC.
was BS.
Okay. The BTC authorities had released fixed remuneration of rupees 900 per month to the petitioners for a period of 1/11/1995 to 31/10/1997, and thereafter no payment was released. Stop. It appears from the materials available in the writ petition that the service of the petitioners were provincialized pursuant to government letter dated 26/3/2013, and and thereafter they were receiving regular salary after provincialization. And therefore, the petitioners, the writ petitioners were only claiming the amount covered by non-payment of monthly stipend amount of rupees 900 per month after October 1997. Full stop. The petitioners had also, the writ petitioners had also stated that though most of though service of most of the petitioners, most of the writ petitioners was provincialized. But there are some petitioners whose service were yet to be provincialized, but they have also not received their stipendiary grants till date of filing of the writ petition. In the affidavit in opposition filed on behalf of the respondent numbers 5 to 7 in the writ petition, being the being number 5, the Bodoland Territorial Council, represented by its principal secretary, number 6, the secretary, the Bodoland Territorial Council, and within bracket 7, the Director of Education, BTC Kokrajhar. In their affidavit in opposition filed on 22/4/2016, have accepted the statement made in paragraph 5 of the writ petition, whereby the petitioners had claimed that the BTC authorities had given remuneration with fixed pay of rupees 900 per month, with effect from 1/11/1995 to 31/10/1997. Full stop. They have further admitted that thereafter no payment has been made from their establishment to the teachers due to lack of fund allotment received from BAC. What is BAC?
Borderland Autonomous Council, it was earlier, Lordship.
Okay, from BAC, Borderland, Borderland
Borderland Autonomous Council.
Autonomous Council.
Earlier it was council.
Okay. First off, apart from the said admission made in paragraph 6 of the affidavit in opposition, in paragraph 10 of the said affidavit in opposition, it has been admitted on behalf of the said 3 authorities that some venture schools were provincialized by the government with effect from 1/3/2013, but some petitioners whose service were yet to be provincialized and have not received any remuneration of the granting aid from the government till date. Full stop. This admission is found to have been made in the affidavit in opposition, which is filed on 22/4/2016. Full stop. Under such circumstances, the categorical admission of non-payment of the stipend the in the humble opinion of the court, would amount of acknowledgement on debt within the meaning of section 18 of the affidavit in opposition. Sorry, 18 of the Limitation Act, 1963. Full stop. In this case, the petitioners were only stipendiary teachers with a fixed salary of rupees 900 per month. Full stop. This is not a case where the appointments were held to be illegal by any authority.
Lordship, can I say one thing, Lordship? They were also terminated. In our affidavit, we have stated, Lordship.
But
they were-
termination is something, but on that day till you admitted, on that day their services were not terminated.
12/11/2004, Lordship, terminated.
Where is that?
In judgment, page 32, paragraph 6, Lordship.
Page
32, paragraph 6 of Honorable Court's judgment, it is reflected. We have stated, Lordship. Paragraph 11 of our affidavit, we have submitted, Lordship. Petitioner was terminated with effect from 12/11/2004. But could not support any document in the affidavit.
This is from other teachers.
No. Oh, sorry, Lordship.
Are they mother
Yes,
teachers?
Yes, Lordship, sorry. This is another read petition, Lordship.
They were not mother teachers. Next paragraph. At this stage, the learned counsel for the learned standing counsel for the petitioners has submitted that the categorical stand in paragraph 11 of the affidavit in opposition filed in the writ petition, comma. The stand of the BTC is that the
Sorry,
said authority had already terminated their services with effect from 12/11/2004.
Lordship, sorry. It is another case, Lordship, sorry. WPC 86409. Lordship.
No, you are right. No, because this is in connection with paragraph 11. You are right. Next paragraph. Therefore, it is in the said context that this court by order dated, by the order dated 23/3/2023 had directed the Director of Education Borderland Territorial Council to make an inquiry as to the correctness of the claim of the petitioners that they have been working uninterruptedly after 12/11/2004 till date in respect of the 50 petitioners, 50 late petitioners, which was directed to be made within 3 months. Therefore, the order of payment would only be for a, the direction to make payment would only be for a period. The petitioners had rendered service. Sorry, the private respondents herein had rendered service. Next, therefore, comma, not in view of the specific admission made in the affidavit in opposition, whereby the authorities of the BTC have not denied the claim of the petitioners of non-payment of their monthly stipend of 900 rupees per month, but they take a plea that their service have been terminated. Therefore, comma, as the direction to make payment is only with regard to the period for which the private respondents had rendered the service. By specifically referring in paragraph 9 to the effect that, inverted commas, that in view of such admission that the petitioners have rendered service up to 12/11/2004, comma, the court was inclined to direct the said herein before referred 3 authorities within bracket respondent numbers 5 to 7 in the writ petition to release the admitted amount of stipend for a period from 1/11/1997 to 12/11/2004. The court does not find any reason to review the order in question so as to deny the petitioners a very minuscule stipendiary benefit of rupees 900 per month, and that too for a limited period up to 12/11/2004. Next, therefore, comma, the court, having not found any merit in this review petition, stands dismissed.
Lordship, kindly consider our interest part also, Lordship.
Pardon me?
Interest part, Lordship, 9%.
That will continue. We can't help it. If you don't pay, it will continue.
Applicable.
900 rupees per month if you can't,
9%.
if you don't want to pay. That also for about a year. That will be too bad.
Lordship, applicable.